Well, good morning. We're going to call this session of the hearing examiner of the City of Issaquah to order October 15, 2018. And we're here today because of an appeal filed by Talus Management Services, who's the applicant and appellant against the City of Issaquah, that issued a notice of administrative decision on March 5th, 2018. There have been several continuances of this appeal hearing date, but here today we intend to move through the appeal with the lead attorney for the applicant and appellant here and ready to proceed. The city attorney is here and ready to proceed. And I don't think we need any more introduction. It's been fully briefed by both attorneys prior to this appeal hearing date, and we have identified witnesses to be presented and the issue that must be decided. So I'm hoping through this appeal, the attorneys will take the lead and help me then understand what issues remain and if there are any disputed facts. This is primarily a legal issue, it appears to me, but there may be some disputed facts, and if so, I want you to draw my attention to those so that I make sure I address them in my decision. My decision will include findings of fact and conclusions of law. I think the law issues have been fully briefed. I certainly have a grasp of them, but we're here today to present witnesses which are typically presented on any factual issues that might be disputed by the parties. So we'll focus on that today. I have been informed upon my arrival today that this hearing room must be vacated no later than 2 o'clock today. So my hope is we move through witnesses expeditiously, but if there needs to be another hearing date, we will identify one just before 2 o'clock. The proceedings are being recorded, and as both attorneys know, if there is any appeal of my decision, it'll be based only on the record that is developed during this hearing today to facilitate presentation of witnesses. I've handed to both attorneys prior to commencement of the hearing the identification of the witnesses that have been submitted prior to the hearing date today and a list of the documents. There are extensive documents submitted, and my course of conduct in a hearing like this is to presume that they are admitted into the record. If there's any that are disputed, that the attorneys believe should not be part of this record, and it's your obligation to bring those to my attention, either at the time they are presented through a witness or by any preliminary motions to exclude exhibits. Otherwise, the exhibits that are in these volumes in front of me will be part of the hearing record. All right, I think we're ready to begin. And unless there are any preliminary motions, we'll ask the appellant to move forward. Mr. Issaquah, City Attorney.
Thank you, Mr. Chairman. The city does have one preliminary point. The examiner is aware from the...
You can check and make sure you're being recorded. I don't hear, I don't see a microphone in front of you.
I might go grab this one.
Sorry. Thanks, Kate.
I can tell that's live, so please, please proceed.
Thank you, Mr. Examiner. Again, Zach Lill on behalf of respondent, City of Issaquah Development Services Department. As the examiner is aware from the briefing and motion practice in this matter, it is apparently the appellant's intent to produce and introduce evidence at today's hearing that bears not only on the question of which process is appropriate for their underlying request, i.e. their request for an administrative minor modification, but also the substantive criteria for satisfying the requested administrative minor modification. The examiner has, I believe, ruled on that issue in the examiner's order on dispositive motion dated July 17th, 2018. However, the appellant has subsequently indicated through its pre-hearing brief its intent to still present evidence on that point. And the city would like to preemptively object to that for the reasons set forth in our briefing and in our previous response to the appellant's dispositive motion. And we would respectfully request in a preemptive order by the examiner that limits the scope of today's proceeding to just the procedural issue.
Would you like to respond to that?
Yes, Examiner Hunter. Jeremy Eckert, representing Talos Management Service, the master developer. Talos Management Services submitted the AMM request, not asking for the director to rule on the procedure, but TMS submitted the request with the correct procedure and also with materials demonstrating compliance with the AMM approval criteria, asking for the director to not only rule as a administrative minor modification that this is correct, but also to approve the AMM. During this process, the master developer worked with the designated official to provide additional material to demonstrate the approval criteria. And this is why we're asking for a remand not only on the procedure, but on the merits itself. And if I can go a little bit further, now that we have the public records that we requested, the remand with direction to the director is even more important, because what we see here is that this issue was prejudged by the mayor, where on December 27th, Mr. Nevin states that he is ready to make a decision, and he tells members of the Talos community that he is poised to approve the request for 17B. On January 17th, after receiving opposition emails from Talos residents, the mayor emails the designated official telling him that she believes the request to be a major modification. But then a week later, and this is the first time the mayor then asked Director Nevins for a copy of the development agreement. So here, the remand is important with direction because we have a prejudged issue that's based upon public opposition and neither appropriate basis for a land use decision. That's why we're asking for that remand request.
Okay, well, we have a bit of a flurry here before there's an actual issue presented to me, because I'm not sure what you're going to present through your witnesses and documents. So I don't think it's right for me to rule on this quite yet. I appreciate that you identified the concern, and I have a better sense of where you want to go with it. And so let's see what happens during the course of the hearing, and you can renew your objection if you think it's wandered into a substantive area that would be inappropriate for me to address in my decision. I would say that part of a ruling that the appellant is asking for, that there be a remand, it has those two components, a remand or a remand with a directive. And I'm not sure how far you're going to go with that, but I'm going to reserve any judgment on that until I see what's presented during the course of the hearing. So no ruling. That's rare that I don't rule, but I will not rule at this point. And we will continue then with the presentation of witnesses, unless there's anything further as a preliminary matter.
Not for me. Well, yes, thank you. Mr. Lell and I conferred before this hearing began, and we both agreed, and I'll let him say that we both agreed to stipulate that all the exhibits identified in the sheet that you prepared should be admitted.
Okay. Thank you for doing that.
The city does so stipulate.
Okay. Then we are ready to move forward with presentation of witnesses. Unless, did you want to do a brief opening comment?
Thank you, Examiner. Yes, just a few opening statements. Just quickly, my name is Jeremy Eckert. I represent Talos Management Services in this appeal. Talos Management Services is the master developer at Talos. As you'll hear today through testimony, the Talos development agreement establishes a bucket of authorized development. This authorized development has is entirely pre-mitigated, and the development agreement provides the master developer with the right to move around these pre-mitigated development through the administrative minor modification process. Here, the master developer requested a minor modification to change the land use designation of 17B to medium density residential, as we've identified in the briefing, and also to change utility tract C to either medium or high density residential as chosen by the director. The designated official denied this AMM request, concluding that changes in land use designation are appropriately characterized as a major modification. As we identified in a pre-hearing briefing, changes in land use designation are authorized in Section C 9.0 and 9.1. And then Appendix K 2.2.2 states that the director shall approve conditions with AMMs that satisfy the approval criteria. During this hearing, we will demonstrate the designated official has repeatedly changed land use designations as an administrative minor modification. So we'll work through that process. And as I just walked through, we will also demonstrate that this issue here today was prejudged and based upon public opposition. We will also provide testimony showing that TMS prepared materials that demonstrate compliance with the AMM approval criteria. So with that, I'm willing to go on with the testimony.
Thank you. You've scoped the issues for this hearing, and we'll now hear from witnesses.
Would the examiner like the city to give its opening statement first, or wait until the city's case in chief is presented?
We'll now continue with witnesses
Thank
from
you.
the appellant and allow
Thank you very much.
the city to present an opening statement at the time it
Thank you.
presents its
Okay.
witness.
I'd like to call Darren Pugh, please.
And I think we have the microphone at that podium, although this looks more like the witness chair, but that's where we have, what's best for you as the attorney examining
I think it'd be,
witnesses?
Darren, do you have a preference? I think it might be easier to sit. I don't know.
Depends on how long I'm going to be up here, I guess, right?
I think he needs to be with the mic.
Okay,
Sorry, Jeremy.
not a
The
problem.
witnesses shall stand throughout the record and
Just say, I think there is a stool, 1 second. Example.
There's a stool. Yeah, here we are.
Good morning to you, sir. If you please raise your right hand and take the oath.
I had to
Do you
figure
swear?
out which my right hand was.
That's your right. Do you swear or affirm to tell truth in testimony you give today?
I do.
Thank you.
Thank you. Good evening, Mr. Pugh. Could you please state your name and spell it for the record?
My name is Darren Pugh, D-A-R-R-E-N, last name Pugh, P-E-U-G-H.
Okay, and what is your title?
Development Manager
Okay, development manager for who?
for Talus Management Services.
Okay. And could you please describe the role of Talus Management Services at Talus?
Talus Management Services took over as a master developer in 2007. In general, the master developer is responsible for coordination and implementation of the development agreement, which includes allocation of density, changes in uses, and other obligations that are outlined in the development agreement.
Okay. Does the development agreement establish what's allowed development?
Yeah, the original development agreement, I believe, established 1,760 residential units overall, and an additional, I believe it was 800,000 square feet of office as part of the approved development plan.
Okay, and is this allowed development mitigated?
It was fully mitigated at the time, I believe it was adopted in 2000, I believe.
Okay. And does the development agreement allow you to move around these densities, these pre-mitigated densities?
Yes, the master developer was in control of the densities, and throughout the development agreement, both prior to us becoming the master developer, as well as during the time that we were the master developer, yes, densities were designated to specific properties as they developed throughout the project.
Okay. And then just quickly, why did TMS or Talus Management Services purchase the right to be the master developer?
In 2007, we were working with the previous master developer, and we came to an agreement to not only purchase the remaining development parcels within Talus, but also at the same time accept responsibilities that were remaining for the master developer that were ongoing obligations, which also then included the remaining density that had not been allocated at the time that it was transferred to Talos Management Services.
Okay, and you talked about remaining density. Is that the same as the term that's been thrown around, ERUs?
I would term them the same, yes. The ERU would be an equivalent residential unit, which can be converted from commercial to residential, but essentially it's a residential unit or equivalent.
You talked about converting ERUs from commercial to residential. How does that happen?
I can't speak specifically because I was not involved in the process. I do know that the previous master developer transferred approximately 300,000 square feet of commercial density allocated to parcel 17, which is now 17A and B. And I think other witnesses can speak to that process,
Sure.
but it was essentially transferred from commercial to residential use for the LCS Timber Ridge development.
Okay. Do you know if that was a minor modification?
I believe it was, but
Sure.
again, I did not process that, so I don't know for sure.
Okay. Have you been involved in processing administrative minor modifications at Talos?
Yes, we've been involved in a number of administrative modifications throughout the 10 years that we've been involved.
Okay. So what sort of items are subject to administrative minor modifications?
They vary. They can vary from sidewalk variances, street variances, width, et cetera, that are different from the code. They also include changes in density up and down, both in both directions, as well as the transfer of density to other parcels.
Okay. Do they involve changes in land use designation?
Changes in land use designation. In the development agreement, there are identified land uses and densities. So yes, they involve changes in those densities, at least in the ones that I've been involved in.
Okay. Does it involve changes from, for example, utility tract to office?
We've never,
Haven't done that.
we haven't done that. So the ones that I was involved in were primarily residential.
Sure. Can you please describe the administrative minor modification process under the Talos Development Agreement?
Excuse me. Typically, it's an application that's made. There's supporting documentation as to what the specific modification is for and what the justification for that is, and that's filed along with an application fee and then processed through the Development Services Division.
Okay. Approximately how long does that process usually take?
It varies depending on what it is, but it's typically a couple weeks to, a couple months.
Okay. The examiner's approval, what I'd like to do is hand the witness the exhibit so we can just
Yes,
walk through.
please. Mhm.
Mr. Pugh, I'd like to direct your attention to Exhibit 10 there, which is AMM 14-0006. Do you have that in front of you?
Yes, 14006.
Great. Did you prepare this did TMS prepare this AMM application?
Yes, we did.
And what was the objective with this AMM, or administrative minor modification application?
Under this particular modification, the applicant for parcel 7 and 8, actually, and Talos Management Services combined, we're processing a preliminary plat application And that preliminary plat application modified both the parcel size for parcel 9 from what's identified within the development agreement. Parcel 9 was increased in size, and then based on the application and the existing density that's identified to those parcels within the development agreement, the densities, allowed densities were modified to meet the appropriate density to the application.
Okay. And did the city approve this AMM?
Yes, they did.
Okay. Here, could you please describe TMS's request to transfer the ERUs to Track C? And now I'm shifting away from the exhibit and just asking a question.
Yeah, the request to transfer to Track C was essentially a method to place the remaining density that was unused under the development agreement and associate that to a particular parcel. This was done primarily as a result of conversations and numerous discussions and meetings that we had with regard to the potential and eventual termination of the development agreement. Over a period of several years, we discussed potentially a request to extend the development agreement to allow time to find ways to utilize the unused density, which I think has been identified as approximately 287 units. Obviously, the density has value, so we were looking for options of how to preserve the rights associated with that mitigated density. So as a result of meetings with Keith, Mr. Niven, at his suggestion, that was a parcel that we still owned and would be allowed to transfer that density there for, I guess, future use, for lack of a better term.
And what was the mechanism to transfer that density to Track C?
The AMM application.
Okay. And did Director Niven direct you to file the AMM application?
It was at his suggestion that we file that AMM to attach that to parcel C, or
Okay.
Track C.
And did you provide Director Niven with all the requested information?
Yes, we prepared an application. Triad worked with us to prepare the appropriate information, and that was submitted to the city for review.
Okay. Now, the AMM request includes information going to Track C, like you just discussed, but it also includes ERUs being transferred into 17B. Can you please describe the background between TMS transferring the ERUs to 17B?
Yeah, in conjunction with, again, these ongoing discussions with regard to the development rights and the sunsetting of the development agreement, again, over that period of years, we have had a number of discussions both with TriMet, I'm sorry, it's what?
I believe you're Talos Corporate Center.
Talos
correct?
Corporate
Yeah.
Center, who's the owner of the office parcel 17B, about options for them to utilize the density and development rights that have been applied to 17B. I know they have had discussions with Mr. Niven as well, kind of separately and together, and so I think from the discussions that Talos Corporate Center had, they approached us to transfer, potentially through their discussions with Mr. Niven, some residential density that they could utilize as part of their development. And so as this came together, we we're both moving in that direction, and so we incorporated both requests as part of the AMM.
Okay. So is it fair to say that you worked with Director Nevin for months to prepare the AMM materials?
Yeah, it was several months to get to a point of application.
Okay. And did Mr. Nevin ever state that changing the land use designation through the development agreement is appropriately characterized as a major modification?
No.
Okay. Did Mr. Nevin ever state that it was a close issue whether this process should be allowed?
No.
And did Mr. Nevin ever state that changing the land use designation is tantamount to a rezone?
No.
Okay. If you could turn your attention to Exhibit A4.
Is that tab 4?
Tab 4, thank you. Which is the AMM decision, which is subject to this appeal. Mr. Pugh, have you read this decision?
Yes, I have.
And what is your response to the director's conclusion that the requested change is not an administrative minor modification?
Given that I'm not an attorney, I guess our opinion is that, this decision is not consistent with discussions that we had with Mr. Niven. It's not consistent with other applications and approvals that have been done within Talus management, or within Talus, under the development agreement, and that it essentially limits the development rights that we acquired under the acquisition and transfer of the density to Talus Management Services as master developer.
Thank you. What does this decision do for your property rights that you acquired?
It essentially deletes any remaining density and mitigated, mitigated density credits that we previously had. This decision, along with in combination, and one of the reasons we did this initially was in order to vest this prior to the sunsetting, because we were not successful in getting the city to agree to or even consider an extension. So what was the initial question? Sorry.
What does this mean for your property rights?
Oh, so we've essentially lost the rights to any mitigated density credits
Okay.
that were remaining.
Thank you. I don't have any further questions.
Hey, does the city have any questions for this witness?
Yes, Mr. Examiner. Good morning, Mr. Pugh.
Good morning.
I believe you have a copy of the appellant's exhibits in front of you.
Yes.
And could you please turn to exhibit number 2, please? For the record, that's a November 21st, 2017 letter from Mr. Patrick Mullaney to Mr. Niven.
Mm-hmm.
Mr. Pugh, when you indicated, I believe, that the TMS group or your company had spent, I believe you said, several months or at least a few months in preparation to submitting an AMM request to the city. Was this the culmination of that request?
I don't know if this is a culmination, but based on, again, meetings with Mr. Niven, which also included Mr. Mullaney, as far as at least being involved in conversations related to this application, this was a part of that process,
Okay.
I guess.
Let me ask the question in a different way. Are you aware of another document, another formal application or request made to the city for an administrative minor modification by TMS to accomplish your proposed residential classification before this November 21st document?
I don't have the dates in front of me, so I'm not,
Okay, thank you.
I'm not, I can't answer that question because I don't have the dates or the other documents.
Fair enough, thank you. And with respect to the various meetings and communications that you alluded to during your testimony with Mr. Niven, did Mr. Niven ever assure you that he would approve an AMM for the proposed request that you were referring to?
No, there was never a specific assurance.
Thank you. And calling your attention to the AMM designated as AMM 14-00006 that you referred to in your testimony, and I believe that was set forth at Exhibit 10. Did that AMM reclassify the underlying property at issue in that proposal for a residential use?
Reclassify from
Did it
what?
redesignate?
It redesignated residential uses from existing to a modified density under residential.
Okay, so just to clarify, if I understood you correctly, Mr. Pugh, before that AMM was applied for and issued, the underlying property was already designated for residential uses under the development agreement. Is that correct?
Correct.
Thank you. Mr. Eckert, I think it might be easier. Could you please hand the witness a copy of Exhibit 1, the development agreement? Thank you. Mr. Pugh, could you please turn to Exhibit or Attachment C in Exhibit 1? And specifically, the table entitled Projection of Possible Density Ranges to Development Parcel that is set forth at Section 4.1. Are you familiar with this document?
I am.
Okay. Could you please look at the reference in the table to development parcel number 17? And under the column entitled Proposed Land Use, what is the designation of parcel number 17?
Office campus.
And in the column immediately to the right of that, entitled Projected Density Range, what is the reference provided for development parcel number 17?
Not applicable.
Thank you. Could you please scroll down to the reference to Tract C? And state for me the proposed land use provided for that tract?
Utility?
And what is the proposed density range provided for that tract?
Not applicable.
Thank you. I believe in your direct testimony, you indicated that you were either aware of or personally were involved in several previous administrative minor modifications under this development agreement. Is that correct?
That's correct.
Could you provide an estimate of roughly how many AMMs you were personally involved with or otherwise aware of?
Off the top of my head, maybe 6,
Okay, over the course of approximately how many years?
10 years.
Great, thank you. During that period, and with respect to those administrative minor modifications, are you aware of any proposed modification that was processed as an AMM which involved the redesignation of the land use category to residential from a parcel, a development parcel the density for which, the density range for which was listed as not applicable under section 4.1 of attachment C?
Based on the table, and I was not directly involved because it was prior to TMS acquiring, but I believe it would be applicable that parcel 17, which was listed as office campus, was redesignated under, I believe, an AMM. Again, I did not process that, to transfer, again, I believe 300,000 square feet of office density to residential use.
And do you know the identification number or date?
I don't know. I
You
was not involved in that. Again, it was prior to TMS being involved as the master developer.
Okay.
Can you clarify for me? The question was asked about reclassification. The response was redesignation. Are they the same thing?
I'm sorry, I should make a point of clarification. I've been using those terms interchangeably as equivalent terms of art under the agreement.
And that's
agree.
acceptable
That's
to you?
acceptable.
So when I hear redesignation, it could mean reclassification and vice versa? There's no critical distinction between the two?
No, thank you, Examiner Hunter. The development agreement calls it a land use designation. So that's, I think, the correct term of art, but I understand what Mr. Lell is saying when he says classification.
But rezone, I should not look at that.
Correct.
So designation is the term we'll try to use, consistent with the agreement.
And just to clarify your last answer, Mr. Pugh, you are not aware of the specific AMM that you alluded to that would have characterized or changed the designation of at least part of tract or a parcel 17 to allow for residential uses?
That is correct. I'm not aware of the specific designation or AMM or whatever process was there. Again, it was prior to our taking over as master developer. I'm aware of the action, but not the specifics.
Thank you very much. No further questions.
Do you have any redirect for your witness, Mr. Eckert?
Yes, I do, Examiner Hunter. Mr. Pugh, you have the development agreement in front of you, correct? The big black binder titled A1?
Yep.
And you were just asked questions by Mr. Lell regarding the table under section 4.1? Mm-hmm. Would you please turn to what's page C5 and 4.1? This titled Projection of Possible Density Ranges by Development Parcel.
C5. Okay.
Okay, and you see it section-
That precedes the table, yes.
Correct. Could you please read the paragraph, section 4.1, that begins, "The table below"?
Section 4.1, titled Projection of Possible Density Ranges by Development Parcel. The table below provides a preliminary analysis of anticipated residential density ranges for the different development parcels within Talus. This table is not a standard and shall not be implemented as such. The intent of this table is to provide a general basis for density allocation and how actual residential types may be developed within Talus, period. These are projected density ranges only and are subject to modification based upon site conditions, market analysis, and other factors affecting density. See Exhibit C1.
Thank you. Does this paragraph accurately describe your understanding of how the development agreement should be implemented?
Yes.
Okay, no further questions.
No further questions, Mr. Examiner.
Thank you, sir, for being here today and offering your testimony. The appellant have other witnesses you'd like to call this morning?
Yes, Examiner Hunter. Next, I'd like to call Ken Bellamy.
morning. Please raise
morning.
your right hand. Do you swear to tell truth and testimony you give today?
I do.
Thank you.
Okay. Good morning, Mr. Bellamy.
Good morning.
Could you please state your name and spell it for the record?
Ken Bellamy, Kenbellamy.
Mr. Bellamy, what is your professional title?
Managing Director,
Managing Director of,
TriMet Development.
okay. And what's the relationship between TriMet Development and Talis Corporate Center?
TriMet owns an interest in Talis Corporate Center.
Okay, thank you very much. And could you just briefly describe your experience in commercial real estate?
I've been involved for about 40 years in the Puget Sound marketplace for real estate, both always as a developer, both of residential and commercial properties.
Okay, are you primarily a developer?
Yes.
Okay. Does Talis Corporate Center or TCC own property at Talis?
It does.
Okay. And what property do you own at Talis?
It's parcel 17B.
Okay. Are you familiar with the development agreement?
I am.
Okay. And could you just please describe your understanding of the Talis development agreement?
It controls the development of all of the Talis community, and it authorizes a variety of commercial and residential uses throughout that community. It provides that all the mitigation has been paid for when the agreement was entered into, so the property is all mitigated. And it provides that the master developer can move the different uses around within the Talis community in order to address the flexibility objective that's in the development agreement.
Okay. And you mentioned the flexibility objective in the development agreement. Could you please just briefly describe the flexibility objective?
My understanding that was put in there, I was not part of the original development agreement, but my understanding is that provided the opportunity to address changing market conditions.
Okay. Do you have any permits for Talis 17B?
We do.
And please describe the permit that you have.
It's a site development permit.
What does it authorize?
It provides for 516,000 square feet of office.
Okay. And were there any sort of modification approvals that were necessary to achieve 516,000 square feet of office?
The parcel 17 was originally approved for 800,000 feet of office, the whole parcel. And it was, part of it was sold to another entity, and the land use was changed from commercial to residential, and that left us with 500,000 feet. And so we needed, well, we didn't need, but we had the opportunity to do a little bit more than that. And so the additional square footage over 500 was done by the master developer converting residential to commercial use, which was, I think, at one dwelling unit equaled 1,200 square feet of commercial.
Okay. So just so I understand this correctly, the master developer converted residential units to a commercial square feet, is that correct?
Correct.
Okay. And did the director approve that conversion?
Yes.
Okay. Have you applied for administrative minor modifications on parcels?
Excuse me, Mr. Jack, before you move on, I take it you have an exhibit that supports that testimony? Can you reference that one?
No, we do not have an exhibit for that. That was done through the site development permit for 17B. We could provide
Not
that.
as a part of a...
No, we could provide that to you if you'd like, and if the city would allow.
Well, no, I asked the question mostly because I wasn't sure if that was an administrative modification or not. And it was not. It was part of a site development permit?
That's correct.
That's
Keith,
correct.
Keith, is that your understanding? Yes.
Yes.
Thank you.
Okay. So Keith, we just to clear up the record, that conversion of residential ERUs to office was completed through the site development permit.
That is correct.
Okay. Have you applied for administrative minor modifications on parcel 17B?
Yes.
Okay. Could you please just, how many times?
Twice.
Okay. Could you please turn to what is marked as Exhibit A9, which is AM 07004 EV?
Yes.
Do you have that document in front of
I
you now?
do.
Great, thank you, Keith. Did you oversee the preparation of this AMM request?
I did.
And what was your objective with this AMM request?
When we were looking at alternative conceptual site plans, the one that we chose to pursue required some additional height on two of the buildings, and so this AMM was that request to make one of the buildings 115 feet tall and one 95 feet,
Okay, and what was the height limit established in the development agreement?
85 feet.
So is it true that this AMM request then was to exceed the height limit authorized in the development agreement?
That's correct.
Okay. Did you have any discussions with the director regarding whether this was a minor or major modification?
I don't recall.
Okay. But I'd like to point you to page 3 in this decision.
Okay.
Could you point, directing you to rationale 4. Can you please describe what rationale 4 tells you about this being a minor modification?
Rationale 4 points out that there was no specific limitation on maximum height on parcel 17, which was the case in a number of other parcels on the property. And the conclusion was that because it was not specifically limited in that way, that that a administrative minor modification was the approach to address our request.
Okay. Did the city approve this request?
They did.
Okay. I'm directing you to A13, which is a letter dated September 18th, 2007, regarding the administrative minor modification request. Can you tell me why this letter was necessary?
Our request also had to be approved by the master developer, Talos Management Services, and this is giving their approval.
Okay, thank you. So, Mr. Bellamy, has TCC constructed 516,000 square feet of office at 17B?
We have not.
Have you constructed anything at 17B?
No, we have not.
Why not?
The market has not been there for it. We got our approvals several years ago, about 10 years ago, which was right at the time that the economy took a major downturn. So we didn't proceed on a speculative basis at that point. We continued to market the property as an office development looking for a pre-lease, and were unsuccessful in securing one. And now, as the economy has improved, the market for the dominant user of new office space, which is technology companies, has shifted to the more urban centers like downtown Seattle, South Lake Union, and downtown Bellevue. So we have continued to market looking for a pre-lease, but have not been successful.
Okay. Do you see any, what do you think your chances are in the near term of securing a lease for office space at this site?
Well, anything's possible, but we're not optimistic.
Okay. Could you please turn your attention to Exhibit A14? And here, this is a letter from you to Lucy Sloman. And I'm directing your attention to page 2 with the subject titled Market Realities. Mr. Bellamy, did you draft this letter?
I did.
And did you send this letter to the city?
I did.
Why did you send this letter to the city?
Well, we were aware that the development agreement was being considered for termination, and wanted to make note of the fact that we had not been successful, the reasons we hadn't been successful, and were hoping to change the use to residential.
Okay. Can you please describe your efforts to establish residential uses at parcel 17B?
Yes, well, it was, we started early on with the thought of doing a change of land use from commercial to residential, and our initial concept was for 77 townhomes on the northern portion of the site and for 400 residential units on the southern portion of the site. Our feeling was that there was merit in that because it had a lower profile in elevation. There was less mass, and the traffic count would have been reduced by about 2/3 from what the office component would require.
Okay. And can you talk about your approaching TMS's approaching TMS for this ERU transfer that's subject to this appeal?
Okay, well, yeah, so our initial approach, we did not get support for that, and so we then were looking to just do the 77 townhomes on the northern portion and retain the office portion in the south. That also did not get the response that we had hoped for. It was then suggested by the city that perhaps taking some of the unused density for residential that was still controlled by the master developer and putting that onto the portion of our site may be a better way to go than a straight change of use.
Okay. So let's just step back a bit. Could you direct your attention to Exhibit A19, please? This is an email from you to Mr. Niven dated August 4th, 2017. Do you have it in front of you?
I do.
Okay, so could you please describe why you sent this email?
We were looking to find a way to proceed with the residential. We were requesting a meeting to do that.
Okay. And then if you could turn the page to Exhibit A20, which is an email from you to Mr. Niven and Ms. Sloman dated November 2nd. Can you please describe the context of this email?
Just thanking them for a meeting that we'd had to discuss the various approaches that might be considered to get residential use on a portion of parcel 17B. And at that meeting, it was suggested that perhaps the purchase of units from the master developer might be the easiest way to proceed. And so we had approached the master developer about that. They indicated a willingness to do it, and we wanted to continue that discussion or further that discussion with the city.
Okay. And do you have an agreement with the master developer to purchase the ERUs?
We do.
Okay. Okay. Did you work with TMS to prepare the AMM application?
We did.
Okay. I'd like to turn your attention to Exhibit A28, which is an email from you to Mr. Niven, with Mr. Hayes, CC'd dated November 29th. Could you please describe the context of this email?
We had considered some different alternatives of doing that commercial on the south and residential on the north, and came up with the master plan that's, or the conceptual plan that's attached, site plan that's attached to this.
Okay.
We're conveying that to Mr. Niven.
Okay. Did Mr. Niven provide you with any direction for the site plan?
Prior to this date, we had some conversations about different approaches that might be taken, and he did provide direction in this, and this is what we ended up with.
Okay. And did you follow the city's direction?
We did.
Okay. Could you turn your attention to Exhibit A33? Can you just please describe the context of this email?
It again attaches the site plan that we were just discussing, and the development agreement provided for what was called an optional project feasibility meeting. We were requesting to know if that meeting needed to occur.
Okay, thank you. So you worked with the city, it appears, for a handful of months to prepare materials.
We did.
Then what happened?
We didn't get any feedback or direction at that point. We were just kind of, it was silent for a few months.
Okay. Could you turn your attention to Exhibit A59?
So before you move on, was it then that December 7th, 17 email asking for a meeting? There never was then
There was not.
a meeting? Okay.
Okay. Could you please describe why you sent this email to the city?
The clock was ticking on the development agreement expiring, and we were very concerned that our request had not been, for the AMM, had not been approved or denied, and the answer was long overdue, but we needed to proceed to do what we could to vest under the development agreement prior to its termination. So we were writing to advise the city that we were going to proceed with a short plat application to accomplish that.
Okay. Did the city ever respond to your email?
No.
Okay. Can you please describe the materials that you provided to the city as a part of your AMM request?
We worked with the master developer on that to provide the material that was required.
Okay. Did the materials address surrounding land uses?
It did.
Could you please say more? Could you please elaborate?
Well, it addressed the compatibility of what we were doing, residentially, being compatible with the residential, the senior housing that was above us, and basically with the rest of the community.
Okay. And did the materials address the adequacy of roadways?
It did.
How so?
I think it relied on the existing EIS that was done as part of the original approval of the development agreement.
Okay. And did the materials address the location impacts of critical areas
Yeah, there weren't any.
on parcel 17B?
Correct.
Okay. Could you turn your attention to Exhibit A4, which is the decision denying the AMM? During your interactions with Mr. Niven, did he ever state that what you're requesting is more appropriately characterized as a major modification?
No.
Okay. And for these are all prior to the decision.
Correct.
And prior to the decision, did Mr. Niven ever state that it was a close issue, whether this was a minor modification or a major?
Did not.
Okay. And prior to the decision, did Mr. Niven ever state that what you're requesting is tantamount to a rezone?
No.
Okay. What is your response to the director's decision concluding that this is best classified as a major modification?
Well, we were certainly disappointed after all the effort and the time that had gone in to try and deliver something that would be acceptable. And we were surprised since it went against what we understood the rationale to be in the previous AMM that we had approved, which is if there isn't a specific prohibition that it could be approved as an AMM. And this ruling was the opposite of that.
Okay. And I want to go back. Are you generally familiar with the development that's happened at Talus since you acquired parcel 17B?
Generally.
Are you aware of any other changes at Talus that have happened in response to the marketplace?
Well, there was the change in residential densities that we heard discussed, and the Talus, the development agreement originally called for a village center. I don't remember what the designation of it was, but it was intended to be a commercial center in the middle of the village to provide services and retail opportunity to the community. And that was never came to fruition, and it's since been built out primarily as residential with some minor live-work units and I think one coffee shop.
Okay. I don't have any further questions.
Do you have any cross-examination?
Yes, please, Mr. Examiner. Good morning, Mr. Bellamy.
Good morning.
I have just a few questions for you. First of all, I'd like to call your attention back again to Exhibit 9. I believe you testified to that under direct questioning from Mr. Eckert. This is AMM 07-004 EV.
Yes.
Could you please look on page 1 of that document under the heading of Request?
Yes.
And please read that request provision to me.
Administrative minor modification to Appendix C of the Talus Development Agreement, allowing some of the buildings to exceed the 85-foot height limit within Parcel 17B. Specifically, the request is that Building D will be 115 feet tall and Building C will be up to 95 feet tall.
Thank you. In your view, did this AMM 07-004 EV redesignate the underlying property from a non-residential use to a residential use
It
under
did
the
not.
development agreement? I'm sorry?
It did not.
Thank you. I believe you also indicated that you were, or your company was able to obtain approved permits to pursue commercial development on the property. Is that correct?
That's correct.
Did the city do anything to thwart or prohibit commercial development on the property?
No.
Thank you. Were you in the hearing chamber today for Mr. Pugh's testimony?
I was.
Did you listen to that testimony?
I did.
I believe Mr. Pugh indicated or opined that it typically takes anywhere, and I'm paraphrasing here, anywhere from a few weeks to a few months to process an administrative minor modification. Did you hear that?
I did.
Does that reflect your understanding or observation as well?
I only had one prior to that, and I don't recall the time frame that was involved in the approval.
Thank you. At any time during your communications with Mr. Niven, leading up to the March 5th notice of decision that is at issue in this appeal, did Mr. Niven ever promise or assure you that your request would be processed as an administrative minor modification?
Processed or approved?
Processed.
I believe that it was processed as an AMM. It was denied.
Thank you. No further questions.
Can you redirect?
No.
Thank you, sir, for being here today and offering your testimony. Hey, do you have additional witnesses you want to call?
Yes, I do. Up next is Al Fury.
Good morning. You swear to tell truth and testimony you give today?
I do. Good morning.
Good morning.
Could you please state your name and spell it for the record?
Al Furry, A-L, last name F-U-R-E.
Okay. And what is your title?
Vice President with David Evans and Associates.
Thank you. And could you please describe the relationship between David Evans and Associate and Triad?
David Evans and Triad merged in August of 2015.
Okay. So when we're looking at the documents here today that say Triad, that explains why you're here today then. Is that correct?
Yeah, yes.
Okay. What are your responsibilities?
So I am a project manager, also principal in charge depending on the project, but I work with the client to determine their goals and objectives. I then work with staff to coordinate and pursue those with documents and submittals and what have you.
Okay. And could you please describe your experience at Talus?
I I started working on Talus in '96 and have worked with the 3 different master developers over the years on a number of different infrastructure design and later parcel development.
Okay. Have you helped clients process administrative minor modifications at Talus?
Yes.
Approximately how many AMMs have you helped clients process?
You know, it's hard to say, but dozens probably over the years.
Okay. What sort of modifications have you seen as administrative minor modifications?
You know, different standards, road standards, drainage standards, density changes, changes in parcel designation, size and shape of development parcels,
Thank you.
whole range.
Thank you. Can you please generally describe the AMM approval process?
So on behalf of the owner promoting the development, an application is prepared that basically describes the request and justification for why it should be approved. It's submitted. Staff reviews, there may be interaction, a request for additional information, and then staff makes a decision.
Okay. And can you speak to the timing of the AMM approval process?
Generally, it was always quite, expeditious, a matter of weeks, sometimes months, but usually pretty quick.
Okay. Are you aware of a time when the city has required a change in land use designation to be processed as a major modification?
No.
Okay, I'd like to go through a series of AMMs now. And Examiner, what I'd like to do is I have an exhibit from the development agreement that has a map of Talus. And what I'd like to do is set it up and work with you so everyone can see it, so we can point out what's changed through the AMM process with your approval.
Okay, and you have that on?
I do, it's right
a whiteboard of some sort?
Yeah.
Okay. And the map is within the exhibits somewhere, correct?
Correct, yes.
Yeah. Do you have a pointer?
Yeah, I do.
And this map here that you have is an
That's correct. It's
illustrative exhibit?
It's an illustrative exhibit within the development agreement, and this is exhibit C. It's exhibit A1 on page C20. And Mr. Fury, I apologize about the awkward setup here. We'll work through this. Okay, so you're going to need to have this task of looking at exhibits while pointing at the map and answering questions. So let's try our best here. I'd like to direct your attention to exhibit A5.
Yeah.
Which-
I have it here.
Which is exhibit AM04001EV.
Yes.
And what I'd like you to do is turn briefly to the second to last page of this exhibit, which is titled Notice of Application, dated January 12th, 2004.
I have it.
Can you please read this notice of application started with "notice is hereby given" and stop after you get done with the second bullet point?
Notice is hereby given that on January 8th, 2004, an application for an administrative minor modification at Talus was accepted for the following request. 1, authorize the conversion of the proposed parcel 17A office area to residential use, and 2, determine Life Care Services is a compatible use with the office campus.
Okay. Did you work on behalf of the applicant for this AMM?
Yes.
Okay. And does this accurately describe your client's objectives?
Yes.
Can you please, on the map, describe what this AMM accomplished?
Sure. So you'll notice here parcel 17O, and the easterly portion is 17A, and the request was to provide for residential units on that portion of 17O.
Okay. And did the director approve this AMM request?
Yes.
And what did this administrative minor modification actually modify?
So it allows a continuing care senior residential community within parcel 17 on parcel 17A.
Okay. Thank you. Now, I'd like to direct your attention to Exhibit A6, which is the file for AM03-006 EV.
Yes, I have it.
Okay, thank you. Did you oversee the preparation of this AMM?
Yes.
Can you please describe your client's objective for this AMM? And you can feel free to use the chart.
Yes. So, and these are intertwined. So you'll see here on the map, westerly of 17O is parcel 16V, as in Victor. And to the south of 16V was a tract of non-critical open space. And this AMM was to basically expand 16V, reducing that open space tract down to a critical area tract at the very south end, making 16V a larger parcel. And there's also boundary line adjustment, and at the end of the day, there's a portion of 17O that became a portion of 16, and 16V became 16-1, 2, and 3, which, as it was built out, 16, 2, and 3 became a townhouse development, and 16-1 eventually became built out as a townhouse with some live work, and I think there's commercial space occupied by a coffee shop. And then on this portion, the reduced, this property line moved easterly and was the west line of 17A, and 17A became the continuing care retirement community.
Okay, so big picture here. Did this AMM change land use designations?
Yes.
Could you please just walk through the changes in land use designation?
Yes, so this was open space, became designated residential. This
Okay,
was...
so just if I could stop you there for a second. So
I'm sorry.
open space became designated as residential, is that one?
Right.
Okay.
Just southerly of 16V. And then the westerly portion of 17O became designated as residential, being developed later as 16-1 and 2.
So if I can summarize there, is it true then that 17O was designated office before the AMM, and then it became designated, that same property became designated as residential following the AMM?
Yes.
Okay. Did the director approve this administrative minor modification?
Yes.
Okay. Thank you. I'd like to now direct your attention to Exhibit A7, which is the file for AM 03-005 EV. Did you oversee the preparation of this AMM?
Yes.
Can you describe your client's objectives here?
Again, it's an extension of this master plan of this area that was southerly of Talus Drive and easterly of Shy Bear Way. And in order to fully develop out the office portion, Tract E and expansion parcel 21 were brought into 17.
Okay, so did this AMM request change a land use designation?
Yes.
Could you please describe the change?
Changed utility tract E, at least a portion of it, to office parcel, and redesignated parcel 21, expansion parcel, as office parcel.
Okay, thank you. Did the city approve this AMM?
Yes.
Okay. And excuse me, for the last few, when I've said, did the city approve, I meant, did the director approve?
Yes.
Okay, thank you. Okay, I'd like to now shift over to the master developer's most recent request.
Okay.
Did you assist Talos Management Service, or TMS, in its preparation of the AMM request that is subject to this appeal?
Yes.
Okay. Could you please describe the scope of your work in preparing this AMM?
Mainly it was preparing exhibits, and there was also some compilation work on Tract C, looking at the different constraints, the 100-foot buffer that's a requirement along SR 900, existing wetland and stream areas with buffers, and basically evaluating the remaining land and if that land had the capacity to support the density that was being proposed to be transferred there.
Okay. I'd like you to turn your attention to Exhibit A47, which is an email from Mr. Nevin to you dated January 5, 2018.
January 5th?
January 5, yep.
Yes, I have it.
Can you please describe the context of this email?
So yes, I was going back and forth on the exhibit prep, and the question was whether it should be 22H or 22M. There was some question about that, and so I just pushed that out to him to clarify so the exhibit could be accurately prepared.
And does H and M, does H stand for high density residential and M stand for medium density residential?
Correct.
Okay. Well, can you please turn your attention to Exhibit A48? And can you
Yes.
please describe the context of this email?
So I had not heard back from Keith, so, or actually, no, I did hear back from him on the M, but I hadn't heard back whether the exhibit should show 22M or just 22 to be consistent with the way the exhibit is drawn. So I prepared one of each so that they could choose which to use.
And is it true that the applicant gave the director the choice to choose between medium density residential or high density residential?
Could you repeat that?
Is it true that TMS provided the director with the discretion to choose between medium density residential and high density residential?
You know, I don't know.
Okay. You talked about the AMM well, are you familiar with the administrative minor modification approval criteria?
Yes.
Okay, can you please describe the materials that Triad prepared to address the approval criteria for this request?
So in this request, we prepared an exhibit which showed Tract C and the critical areas, buffers, and remaining developable land, and a modification to the land use exhibit that's found in the development agreement showing the proposed land use changes.
Okay, so did you provide information to the director regarding surrounding land use?
Just by virtue of the maps.
Yeah, okay. And the maps identified critical areas then, as you discussed?
Yes.
Okay. And is there any need to address the adequacy of surrounding roadways?
No, because of, again, these were already pre-mitigated units that we're talking about.
Okay. Thank you.
Mr. Eckert, what exhibit reference for that last dialogue? What were you looking at? There are a lot of numbers flying around, but
This was just a testimony, so I'm not citing a specific exhibit here. But the the examiner's
I thought
asking.
your preliminary question on that last exchange was, did you help prepare
Oh,
an application? And what one were you referring to?
sure.
We've had a lot of them in front of us.
That's very true. Well, here I was asking him about preparing the application, but here I could be citing to Exhibit A3, which is the December 7th. So let me ask this question. Mr. Fury, could you please turn to Exhibit A3,
Sure.
which is the December 7th AMM request. And if you scroll through this exhibit, you see that there is a Exhibit 1, which is a TALIS 17B conceptual master plan,
Okay.
and an Exhibit 3 here. Did Triad or your most recent company help prepare the materials for this letter?
So Exhibit 1,
So Exhibit A3,
A3, Exhibit 1, no, I believe the architect did that. And 2 is the existing. 3 is a markup of the BLA that I did not do. And 4 is an aerial view of this portion of the development.
okay. But as we discussed earlier, you did help prepare materials for the master developer that was submitted to.
Yes, yeah, there was an exhibit of Tract C showing the different areas. That just does not happen to be in Exhibit A3. I saw it elsewhere, I just can't locate it.
Okay. And examiner, to keep this moving on, I'd be happy to move on from here and point out that exhibit later with your approval.
Yeah, but here's what I'm left with. In
Sure.
Exhibit 3, this witness did not help prepare the materials that are included in the Exhibit 3 that we have,
That's correct.
but he's referencing another exhibit that is related to this, is that right?
I believe, yeah, so there was additional material submitted to Mr. Nevin as this went on, and Ken Bellamy discussed those materials.
Okay.
So,
So he was involved in preparing materials for submittal of the Exhibit 4, the one we're here today.
that's correct. Yes. That informed the
Not
final
clear
decision. Yes.
exactly what those materials are, but that's okay.
Okay.
He was involved in preparing this application.
Yes,
That's the
that's
subject of the appeal today.
correct. Yeah,
Okay.
that's what we've
So we can
established.
leave that generally if you want, or you can identify specific elements, but right now,
Okay.
my understanding is, yes, he was involved in preparing the materials.
Yes, that's correct. That was the plan. Okay. Okay, Mr. Fury, so we've now established that you were involved in preparing application materials. Have you read the director's decision here, which is Exhibit A4?
Yes.
Okay. And prior to this decision, at any time did Mr. Nevin state to you that this was a close issue, whether this was a major modification or a minor modification?
I actually have had no conversations with Mr. Niven on this
Okay.
at all.
And this was just through, your conversations with Mr. Nevin were just through email, is that correct?
Correct.
Okay.
Yeah.
Okay, I have no further questions.
Great.
Thank you.
Hey, does the city have questions for this witness?
Yes, please. Good morning, Mr. Fury.
Good morning.
Just a few questions for you. You indicated that, I believe, your testimony was that you had no communications with Mr. Niven that weren't email-oriented?
That's my recollection. We had a hard time connecting, so it was back and forth by email.
So no verbal communication?
No.
Thank you. And in any of your email communications with Mr. Niven, did Mr. Niven ever promise or assure you that the applicant's request modification would be processed as an AMM?
No.
Thank you. I'd like to turn your attention to Exhibit A5, which I believe you touched on during your direct examination, and this was the June 24th, 2004 administrative minor modification notice of decision in AM 04-001 EV. Could you turn to that, please?
Yes, I have it.
On page 1 of that decision, could you please read to me the last sentence of paragraph number 1?
The basic land use designation for parcel 17, parenthetical office, remains unchanged.
Thank you. Could you then turn to Exhibit A6? This is the notice of decision dated January 27th, 2004, in AMM number AM 03006 EV.
Yes.
Okay. Could you please read aloud the request statement of that document on page 1?
Application for an administrative minor modification to redesignate non-critical area open space south of Talus parcel 16 to be included as part of parcel 16.
Thank you. Now I'd ask you to turn to Exhibit 1, which is the development agreement, and specifically Appendix K.
Okay.
And under the description of authorized elections for the master developer in section 1.0, and specifically subsection 1.1.7, could you please quote aloud that subsection for me?
The title is Redesignation of Non-Critical Open Space. Inclusion of non-critical open space in a development parcel, parenthetical, whether in one of the development parcels conceptually shown on Exhibit 3, comma, Talus Development Area Exhibit, comma, or in a newly created development parcel, close paren.
Thank you. A final question. I believe that you testified in your direct testimony concerning your experience with the timing of processing of previous administrative minor modifications under the Talus Development Agreement. And I believe, and I'm paraphrasing here, that you indicated that it was typically expeditious, that it sometimes took weeks, but other times took months. Is that an accurate characterization of your testimony?
Yes.
Thank you. No further questions.
2 quick items.
Just a minute. So what was the first exhibit in your cross-examination that you referenced?
That was A5, Mr. Examiner.
Okay, please redirect.
Thank you. Mr. Fury, you were just directed to Appendix K, which identifies elections, administrative minor modifications, and major modifications. Are you familiar with all 3 of these?
Generally, I have staff much more in detail, but yes, generally.
I understand. Thank you. And he just had you read a section from the election section, isn't that correct?
Yes.
Okay. Could you now turn to Exhibit A6, which is AM 03006 EV?
Yes, I have it.
And you just read the request provision out loud, is that correct?
That's right.
Does anywhere in the request use the word election?
No.
Does anywhere in the request state the word administrative minor modification?
Yes.
Okay, thank you. And then, examiner, there was a question before about materials that the witness prepared. If I could direct you to Exhibit A4, which is the notice of decision. And if you could turn to the third to last page, which is attachment 2.
Yes.
Did TRAD help to prepare this material?
Yes, that's the one I was referring to.
Very good. Thank you. No further questions.
Thank you, sir, for your testimony today.
You're welcome.
Being present. So, Mr. Eckert, you have 3 additional witnesses identified.
Yes, there are two more to go. We
more to
have
go.
Patrick Mullaney and Mr. Niven. And I'd like to call Mr. Mullaney next.
Good morning.
Morning.
You swear to tell truth and testimony you give.
I do.
I didn't recognize you without the tie, appropriate attire as a
I'm
witness.
going in witness attire today, Mr. Examiner.
And
I missed the memo.
Mr. Mullaney, could you please state your name and spell it for the record?
Yes, my name is Patrick Mullaney, Mullaney.
And what is your professional title?
I am a land use attorney at the firm of Foster Pepper.
How long have you been a land use attorney?
21 years.
Oh, my goodness.
Okay, and I guess I should note, too, that you were listed as an attorney on our initial documents for the appellant, but you're here as a witness.
That is correct, Mr.
Okay.
Examiner.
And there's been no objection to that, and I don't object to that.
The city does not have an objection.
Okay.
Thank
So
you.
I just note that so we don't have that come up later.
Thank you,
So
Examiner.
please continue with your examination of your witness.
Can you please describe your familiarity with development agreements in Issaquah?
I have, I would say, a significant familiarity. I was one of the attorneys that worked with Mr. Niven and Ms. Sloman and other members of the city to draft the development agreement for the Costco headquarters. As a consequence of that work, I reviewed all of the development agreements that the city had in detail. I'm also very familiar with the Issaquah Highlands Development Agreement, and I've done some work in Tallis, so I had occasion to be familiar with the Tallis Development Agreement.
Okay. Can you please describe your experience with the Tallis Development Agreement?
Well, Mr. Hayes, who is the principal in Tallis Management Services, he also was a landowner with Tallis Parcel 7 and 8, as the examiner well knows, since we sat in a hearing a few weeks ago on Tallis 7 and 8 regarding the landslide that occurred on Tallis 9. So as a result of the landslide-related work and other work, I'm very familiar with the Tallis Development Agreement.
Okay. Do you have the exhibits in front of you?
I do.
Okay, thank you. Could you turn your attention to Exhibit A2?
Yes,
Did you draft this letter?
I did draft this letter.
Okay, could you please describe the purpose of this letter?
Yes, as has been testified before, Tallis Management Services had been in discussions with Mr. Niven regarding the ERUs that it remained that were not allocated, and as a result, the strategy was formulated to apply for these administrative AMMs to do the assignments that are at issue today.
Okay. Could you please describe the background that led you to draft this letter?
Well, I reviewed the development agreement and had some telephone conversations with Mr. Niven, and he suggested these particular sections that are referenced in here, and so I went and reviewed them. He asked me to make a written request, and then the idea would be that Triad would follow up with formal documentation. So
Okay.
that's what this letter reflects.
Okay, so is it fair to say that you followed the director's guidance in preparing the letter?
That's correct.
Okay. Could you please turn your attention to Exhibit A3?
Yes, I have it.
Okay, this is dated December 7th, 2017. Did you draft this letter?
I did draft this letter.
And could you please describe why you prepared this letter?
It arose because of follow-up conversations with Mr. Niven regarding requesting additional information to support the AMMs. As has been testified earlier, the concept of the Talus Development Agreement was there was an EIS done that identified a certain bucket of development and associated impacts. Then mitigation was constructed to offset the impacts of that development. And it started with this Exhibit C1 is, I believe, from the development agreement, original one, as the kind of preliminary whack at potential allocation of land uses throughout Talus, subject to, as was pointed out, the flexibility objectives and market forces that were contemplated will alter that development. So what was requested in this letter was a more detailed discussion of the allocation and the support for that. Mr. Niven asked that we discuss the various criteria for Appendix C, Section 9.1, which occurs on pages 2 and 3 of the letter. And then also, the letter includes examples of past changes in parcel size and parcel designations. That's at the bottom of page 2 and the top of page 3 on parcels 17A and 17B and parcel 16V, and the change of the land use designation of a village center on C1 to a residential use, some of which Mr. Fury testified to just a moment ago.
Okay, so just to be clear, did this letter ask for an inclusion or creation of a new parcel if necessary?
It does. That was for Tract C, and let me see where that is.
And on the bottom of page 1, is that what you're looking
That may well be. Yes, it's the last sentence on page 1. It says, "To the extent conversion of Tract C into development parcel is deemed necessary to allow the density allocation, TMS requests this conversion as well," because that was one of the mechanisms, I believe it's in Appendix K, that allowed the developer to manipulate the parcels, as was done in that previous incorporation of non-critical open space into one of the AMM approvals.
Okay. I'd like to talk about the AMM approval criteria on page 2. Could you please describe how this letter addresses the criteria involving surrounding land uses?
Mr. Examiner,
Mr. Lell?
if I could, please, per your direction at the commencement of this hearing, to the extent that this testimony is going to veer into the area of the substantive approval criteria for an AMM, the city would respectfully reiterate its objection and request that the scope of this proceeding be appropriately narrowed and confined to the procedural or process issue as the examiner's July 17th order on motions indicated.
Hey, Mr. Eckert, is your intent to veer into substantive aspects?
It is my intent to veer into substantive aspects because we will be asking you to remand with direction to the director, and because this information was squarely before the director when he made the decision. So here we have a witness who can testify to this to create the record, and then ultimately it will be your decision on how you wish to proceed.
So you expect my decision to address authority to direct upon remand?
Yes, and the reason why we'll be requesting that will be shown in the next witness, where we'll be showing how this was prejudged and guided by political opposition. And so if you just remand without direction, we'll be back here again.
Well, there may be a difference, though. Now, you've raised for the first time, because of the Public Record Act.
That's correct.
Delay in releasing documents. But testimony on that issue of decision made based on opposition is different, I think, than a remand with a directive. And I would allow you to build the record on the first matter, but
Very, very, very good, and I understand. So with the directive, it seems like the examiner would need information on the AMM approval criteria and the facts that were before the director.
But that material is in front of us. That's clearly in the exhibits.
Very good.
The
And-
criteria and your clients, as we have in front of us, I can read.
Very good. I do
The
not need to have
application.
them. Yeah.
And of course, it's your position that you submitted necessary materials to show that the criteria are met, correct?
Correct.
So we don't really need to go into detail on that.
The thought here would be is that the witness, in this case, Mr. Mullaney, could provide the factual context to help you with the information that's on the page. So I'm not going to ask him
I
to read
allowed
this
you
page.
to do that,
Yeah.
right? You know, he drafted this do we consider this the application? The
Yes.
exhibit before us, which is kind of unique. It's a letter application, nothing additional. This is the application, is that right?
The application was submitted, and then what you just heard with the other witnesses is that the director requested more information to supplement. So I would
Okay.
say that this was application was submitted, but the complete application was all the additional material that was submitted in response to the director's request. Somewhat like if we were doing a building permit application and there were correction letters to come in, and you provide the city with more information. The whole file is the letter plus the additional materials that was sent to the director at the director's request.
Well, maybe you can clarify that with your witness, because again, I think the documents give me the information
Okay.
needed on the substantive compliance that you want to show
Okay.
on behalf of your client. But I am a little unclear of what exactly the application consists of. There's been references to, yes, I helped, I submitted this, oh, it's this plus this. But can you be clear about that through this witness that apparently was the key individual to submit the application? Is that possible?
Yeah, we'll work through that.
Okay.
Yeah.
And I think then once we have that, I can look at those documents without testimony about whether or not it actually complies with the criteria. Does that sound fair?
It does sound fair.
Okay. Is that okay with you, Mr. Lau? I need to know what exactly was in the application.
I think that's a fair question, and that line of questioning is something the city would not object to.
Okay.
Yes.
And let's do that. Go ahead, Mr. Eckert.
Okay. So, Mr. Mullaney, the examiner just asked the question, what is the application? And so just a big, broad question for you is, could you please describe the application process and the materials that you provided to the director?
Yes. So originally, based on my conversation with Mr. Niven, he suggested that this would be a pretty straightforward process, and he directed me to the two reference sections in the November 21st letter that is Exhibit 2. And so we made that application, or wrote that letter, because that's what he asked for, a written request for the modification. Subsequently, we had another telephone conversation, and he asked for an analysis of the approval criteria that are included in the December 7th letter. And specifically, he asked that for Talus 17, that the elevations of the office portion of the development, so the way the parcel was going to be split was there was going to be 77 residential units, and then the office density would be put on, and I may have this wrong, I believe it was track 17C was going to be the new track created for the office. But he asked for a specific orientation of the buildings for the office component so that they would step down the hill to reduce or eliminate any visual impact of the building heights with the Timber Ridge assisted living or senior housing that is located upslope from parcel 17. He also requested an analysis of the critical areas, components of Tract C. And the idea with Tract C was that right now there are stormwater ponds on it. There are also some wetlands and other critical areas. And then that's where Mr. Fury came in, and he had direct discussions with Mr. Niven to provide the requested information that he testified to. In particular, the analysis of the non-critical area portion of Tract C. And I am not sure, I believe from Mr. Fury's testimony, who did the elevation sketches for the AMM for the 77 units that show the building drop down. I guess that must have been.
Are they in this Exhibit A3?
They are.
Part of your submittal that you provided after the telephone conversation?
What is in this exhibit, this submittal, Mr. Examiner, is the conceptual, that this is what I was talking about, 17B and C, and then the various buildings for the commercial stepping down the slope on 17B. So that part is in there.
My question's really very fundamental. A decision was made by the city based on a submittal by your client, and I'm just trying to obtain, Mr. Eckert, the exact application that was ruled upon that you feel you submitted. The city may have a completely different impression, is what I'm gathering. I'm not sure what the decision was based upon, but it's your opportunity to share with me what you believe your client submitted and ask for a decision. And so far, I have Exhibit 2 and Exhibit 3. Now, Exhibit 3 has a number of attachments. But that was, so far, that's what I have as submitted to the city, asking that you make a decision based upon this application. An initial submitter in November, and then supplemented by the December letter.
That's correct. So we would.
Anything additional?
Yes, there are. So we had Mr. Fury testify, and what I'd be happy to do at closing, if with a little bit of time, is to go through the exhibits and identify. The issue here is that we submitted the December letter, which we believe is the application. But we believe that the entire application includes the materials that were requested by the director following submittal of that December letter. We had Mr. Fury testify to some of the materials that he provided to the director. So with your approval, what I would like to do is to provide you with a list of the exhibits here that we believe comprise the entire application that start with our December submittal and that include the additional materials that were requested by the director. We believe those are also appropriately part of the application, so to speak.
Is that a lengthy list?
It might be, because there were a lot of emails from Director Niven requesting materials. So it might be another 8 or 10 emails from Triad going to the city.
Well, I'm getting confused. And now you said started with the December letter. Earlier, Exhibit 2, which is a November 17 letter, that begins the application process, doesn't it?
Sure, that's correct. So let me,
You
allow me to
excluding
back
that now
up.
from the application?
So
I mean, normally, I'm pretty familiar with this land use process. You know, there's a date of submittal, and then there's typically a complete application notice. Now, I know we're under a development agreement, so it doesn't follow the path that's identified in state law. But that's certainly, state law does give us an idea of what components.
yeah, no, you're absolutely right. And we
So
agree with you.
I feel like I'm asking for something simple. But I'm concerned that there's a long list of documents, including emails and telephone conversations.
And this is the issue here. So you're absolutely right. December 21st, we submitted the request. We submitted a more robust request on December 7th. The issue that we had, just like you're having right now, is there were no formal correspondence notices coming from the city to the applicant. Nothing formal. Nothing on city letterhead stating,
Well, the decision.
that's correct, just the decision. But there was nothing stating, we do not have this information, please provide it with us. They came through a series of piecemeal emails from the director to the applicant saying, could you please get me this? Can you please get me that? And so we did our best to respond quickly. That's what many of these emails show. That's what Mr. Fury testified to, what the master developer testified to. And we had the same issue that you're having right now, because we never received city letterhead, we need this information. It was piecemeal emails from the director saying, please hand me this or that, to which we responded. We believe those emails are part of the application because they were requested by the director.
Okay. And you have a list of those emails and the responses.
I can quickly prepare that, yes.
Yeah.
Would you like to take a 10-minute break and I can prepare that material for you?
Well, I think it's important
I do
for
too.
my decision to know what the city's decision was based upon. And do you have the same understanding that the city has? Has this come up before? Have you discussed this with the city attorney, saying these we believe are the application materials that are important? Has that been done, Mr. Lell?
It isn't. I mean, the city has been operating to date under the premise that the application, quote unquote, at issue in this proceeding is comprised of the November and December letters from the applicant's attorney. And we've been kind of scrambling as this discussion has been unfolding to understand really what is occurring here. We would characterize any subsequent correspondence that was exchanged between the city and the applicant as supplemental information to guide and inform the city's ultimate decision, but certainly not part of the original application itself, i.e. those subsequently submitted documents, those subsequent communications were not technically part of the application. It certainly is not consistent with the city's understanding of the term application to include those materials within that.
Okay, so I know we've got a development agreement. It's not the 3670B pathway. But you're saying, Mr. Lell, that the complete application really was that letter in December.
By its terms, the letters were formatted as a request for a particular modification. Any subsequent communications would take the form of supplemental information, not part of the application itself.
Okay. Well, let's do this. I think we do need a break anyway. It's almost noon. I know we're facing a deadline. I'd like to continue into the lunch hour if that's
Yes.
permissible with you and your witnesses. And take the break to share with the city attorney, here's what I think the additional emails are. I don't think that's probably 50 in number. Hope it's maybe not more than 5. Okay, and then we'll see if we can come back on the record and say, these are the additional ones we want you to consider. Okay?
Thank you.
We'll do that and then reconvene in 10 minutes. Okay, we are back on the record for this hearing. And Mr. Eckert, do you have any update for us?
Yes, thank you very much, Examiner. I had a chance to confer with the city attorney, and I believe, and the city attorney can correct me, is that we're agreeing to stipulate that A2 and A3 are the application for the purposes of this appeal, and that the remainder of the documents, which I can go through and identify, are part of the application record, which was before the director when he made the decision. And I can specifically identify those materials right now for you if you'd like.
Please do so.
A15, A23, A28, A33, A42, A43, A44, and A45. I'm sorry, and A47 as well.
Okay, that's helpful. Thank you for doing that.
Thank you for your time.
And now, do you have additional witness
Yes,
questions?
thank you very much,
Okay.
yes. Mr. Mullaney, the examiner asked questions about the application forms for administrative minor modifications. Could you please turn to Exhibit A6? And here I direct your attention to the letter dated December 31st, 2003.
Yes.
Can you please describe what you see here?
Okay. Well, going back to what the examiner rightly noted, the development agreement is a little bit different creature than this typical city permit application. And so the AMM, as I testified to earlier, our AMM, Mr. Niven asked for letters to formally requesting the AMM. And what you're referring to in Exhibit 6 in the December 31st, 2003 is another example of a letter that was, I would say, was an AMM application that is kind of a similar format, more similar to my second letter than my first, but it's basically a letter format. That's how my understanding is the city accepted AMM requests from the master developer.
What exhibit are you referring to?
This is Exhibit 6, and as part of the AMM decision, Mr. Examiner, just following that, there is a December 31st, 2003 letter right behind, I think there's one. There's a two-page decision, and then there's the letter, and that was the AMM request letter that accompanied that application.
Guess I have a different document. Can you help me with that? This is Exhibit A6?
Exhibit A6.
Exhibit 6, and
So this is the AMM for 03006 EV.
Okay, I have that.
okay, so then if you go through the first two pages of that, Mr. Examiner,
Yes.
and then the next page after the first two, so after the signature page on the decision.
I see it now.
Yes.
The triad letter,
Yes,
Niven, dated December 31st, 2003, correct? Okay, thank you. All right.
so, and the only point of all this is that it was my understanding and consistent with what Mr. Niven had requested, that this is how the AMM process was initiated in Tallis, was a letter request from the master developer or his designee.
Okay,
So and this is just an example of that.
thank you.
Thank you, Mr. Mullaney. Could you please turn to Exhibit A15?
Yes.
And here we have a letter from Mr. Niven to you dated December 14th, 2017.
Right, and so this is following our, we had the telephone conversation, I provided him the updated information, and the two things that are discussed here, Mr. Niven is requesting first for the Tract C, he's asking what it will become as far as incorporating it as a new development parcel. That's parcel 22. That's in number 1. And so the 22 refers, and then the designation afterwards refers to the residential density.
Okay,
And then likewise, number 2, he's discussing criteria 9.1C which were the approval criteria, particularly with regards to critical areas. And so he asks how much of Track C is not a critical area, and asks for a critical areas map. So that leads to the discussion between Mr. Niven and Mr. Fury at Exhibit 43, where they have the email discussions regarding the Parcel 22 exhibit and exactly what Mr. Niven would like to see on the, regarding the critical area. If you look at the December 20th email, Mr. Niven says, yes, this is what I was looking for, also for non-critical area, non-critical
Mr.
area.
Mulaney, if I could just stop real quick. Which exhibit are you on right now?
I'm on exhibit 43.
Okay, so on exhibit A43, and what, this is an email thread.
Yes, and so it's on the third page, and this is Mr. Niven responding back to Mr. Fury, and the first thing is in response to the designation of the parcel 22, and then Mr. Niven asks, also for non-critical areas, need a calc of area size. We'll give you a call soon. And so that led to the Mr. Fury providing exhibits that are attached to Mr. Niven's decision, which I believe is Exhibit 4. Is that correct? So if on Exhibit 4, Attachment 1 to Exhibit 4 is my December 7th, 2017 letter. And then Attachment 2 is the critical areas map that shows the various calculations that Mr. Niven had requested. And then Attachment 3 shows two things. One, this is kind of the revised land use map that, if you look over on the right-hand side, about halfway down the map, it shows a parcel 22. That would be where the Track C conversion would have occurred. And then it also shows the split of parcel 17 into 3 parcels, with B and the new parcels being B and C. Well, B is existing, but C would be the new one.
Okay, thank you. Mr. Eckert, is it your intent then to go through each of these supplemental materials and to have a witness identify how they became embraced by the application?
No, I'm just making these
Good.
materials part of the record. We all want to get out
I
of
think
here before
that'd be a
2.
long, lengthy proceeding. That really, I just kind of wrote in my notes, well, so what, you know? But I get it. You're making a point. There was a lot of interactions and exchanges that then affected the final record for review. Is that it?
That's correct.
Okay. And when we can make that point, and I can make even a finding on that without having to go through each one of the emails. Good.
Very
Okay.
good. Thank you. Mr. Mulaney, just a couple of follow-up questions. Did you review the notice of decision at Exhibit A4?
Yes, I did.
And what is your response?
Well, I mean, I disagree with it, and, I find that it was inconsistent, at least with my reading of the development agreement.
Okay. No further questions?
All right. The city have questions for Mr. Mulaney?
Very briefly, Mr. Examiner. Good morning, Patrick.
Good morning.
Or good afternoon, pardon me.
What did you call him?
Patrick?
Oh, Patrick. Okay. Mr. Mulaney, but also Mr. Patrick Mulaney, as colleagues.
Yes.
But he's here as a witness.
Okay.
Okay.
I apologize. Mr.
Oh,
Mulaney.
thank you.
Good afternoon, sir. Just one question. You indicated that you had been involved, I believe, in the drafting of various development agreements with the city of Issaquah. Is that accurate?
I was involved in the drafting of the Costco Corporate Campus Development Agreement. Took approximately 2 years, I would say, with Mr. Niven.
Were you involved at all in the drafting of the Talus development agreement at issue in this proceeding?
I was not.
Great. Thank you. No further questions.
Thank you for being here today and offering your testimony. You have one additional.
Final witness, yes, Mr. Niven. Yeah, no trap. Safety first.
Afternoon.
Good afternoon.
You swear to tell truth and testimony you give today.
I do.
Thank you.
Thank you.
Good afternoon, Mr. Niven.
Good afternoon, Mr. Eckert.
Could you please state your name and spell it for the record?
Sure. My name is Keith Niven. Last name is Niven.
Okay, thank you. And what is your professional title?
My title is Director of Economic Development and Development Services for the City of Issaquah.
Okay. And approximately how long have you held that position?
This specific position, approximately 3 years.
3 years. As the director, do you manage Lucy Sloman?
I do.
Okay. And do you administer development agreements for the city of Issaquah?
I do.
Does this include the Talus development agreement?
It used to, yes.
It used to.
Well,
Why is that?
the development agreement for Talus has been terminated and replacement regulations have been enacted. So other than this proceeding and what might come out of it, everything else is sunsetted.
So it's still relevant, the Talus agreement, to this appeal?
Exactly.
Is that correct?
Yes.
Is that on your determination as a matter of a vested application, or how did you make that determination?
It was that the appeal of the decision was made before the termination of and the enactment of the replacement regulations. So because that administrative appeal was in play, the city recognized the outcome of this being still relevant, I think.
Okay,
that
and
make
that's
sense?
what you
Okay.
agreed
Thank
to
you.
as
Yeah.
appellant. All right, please proceed.
Okay. Thank you, Mr. Niven. The Talus development agreement establishes the designated official under section 32.12 of the development agreement. Were you the designated official for Talus?
So the designated official's technically the mayor, and the mayor then designates it downward to Development Services Director, and actually it was designated down to Lucy Sloman,
Okay.
if you want to actually trace the breadcrumbs.
So how does that designation occur?
It's done through, it has been previously done through email, basically between the mayor and Ms. Sloman. It's my recollection.
So I'm just a little confused.
Sure.
If Ms. Sloman is the designated official, why was your signature on the AMM notice of decision?
So because I am her, I'm her boss, basically. So there's this, right now, the administration of the development agreements are assigned to Development Services Department. And because I'm the Director of Development Services Department, it is within my care. And whether or not I sign as designated official or Lucy Sloman does, I don't know that there's a difference to the city.
Okay. And then can the mayor then sign as well underneath the development agreement?
Technically,
Okay. And does that require a formal email exchange about who's the designated official, or is the city's position that just any one of you three can sign as the designated official?
so right now, the designated official position is myself, and that has been since so I used to be the program manager of the city's major development review team before its sunset. in 2012, and I was the designated official for that, which oversaw the administration of both the development agreements for Issaquah Highlands and Talus, and then Rowley, before it was merged into development services. At that time, I was the director of economic development for the city. I was not involved in development services during that time because the director of development services, Charlie Bush, did not have a land use background. He assigned the designated official position to Lucy Sloman. When I took over as development services director 3 years ago, I retook over the designated official position. So that's the saga.
Appreciate
Hey,
that.
that's an interesting story. Are you going to ask me to
I got 1,000
rule on
of them.
authority? Because that hasn't been raised as part of your appeal.
I'm not, that's correct. What I'm trying to figure out is who had the authority to make this determination. I'm not asking you to rule on that, but it's just a question of when the city's making its determinations, where does the buck stop? Who makes the determination? Are other people making the decision when they shouldn't be? That's this line of questioning here.
Right, and I understand, and it's probably relevant in some context, but not today.
Understand? I'll move on. Thank you.
Unless I'm wrong about that, you're not asking me to rule. That is often a question about how did you get that authority? I think you established it sufficiently. Did you need to do anything more for this record?
No.
Okay. Please continue.
Okay. Did you draft the AMM decision that was the subject of this appeal?
Yes, I did.
Okay. Did anyone assist you in drafting the AMM decision?
City attorney did.
Okay. Anyone else?
No.
Okay. Did anyone else inform your thinking in the AMM decision?
Did anyone inform?
Yes.
Sure. So part of any public decision-making process includes comments from the community, and there were definitely a lot of comments from the community about this AMM request. But no other staff.
Okay. Did any elected officials inform your decision on this AMM decision?
No.
I'm just curious about comments from the community. Is this something that's noticed, the application? Is it you give it a public notice?
Yes.
How's that given?
So it's given a project number. So the decision was,
Well, let me ask more specifically. Do you provide mailed notice or published notice or posted notice? The application?
for an AMM request, there is not public notice, so it's not noticed out to property owners within 300 feet. But it does show up on the city's project list, I believe.
That's how the public would have known about it, looking at the project list.
Plus,
and then
we were
provide
engaged
comment.
at the time with the Talus community as part of the ending of the development agreement and
Okay.
adoption of the replacement regulations.
Okay,
when
and
it
is
came
there
up.
a time period for public comment? You say must be submitted by a certain date?
No.
So you considered public comment up until the day you issued the decision?
Yes.
Thank you.
Do you always notice administrative minor modification applications?
I don't know the answer to that. I don't take care of that level of detail, so I don't know. I'd have to look in the development agreement and see if there's an obligation to notice. I think I said we did not notice, but I'd have to double check and see what the development agreement says in terms of processing for public notice. I could do that if that's important.
Okay. Can you please turn to the development agreement, which is Exhibit A1, that
Yeah.
big black binder there?
I brought my own. It's got tabs.
You can do that one too.
Mine's in a white binder.
So if we turn to Appendix K,
Yep.
there's and the city attorney did a good job briefing this. There's a list in Appendix K, page K7, Section 3.0 is major modifications.
Yes.
And one of these major modifications is in 3.6, where it says changes from low to high density residential. And you would agree that changing low to high-density residential is a major modification, is that correct?
Specifically identified, yes.
Okay, thank you. Oh, thank you very much, Mr. Lowe. Can you cite to any provision in the development agreement that specifically states that it is a major modification to change the land use designation from utility tract to medium density residential?
Specifically, no.
Okay. Can you specifically cite to any provision in the development agreement that states that it's a major modification to change the land use designation from utility tract to high density residential?
No.
Okay. And for 17B, can you specifically cite to provision that states that it's a major modification to change from office to medium density residential?
No.
Okay. Were you around for any of the, were you the planning director for any of the, let me back up. Were you present for today's earlier testimony?
Yes,
And did you listen to the testimony?
I did.
Okay. So you were here for the discussion of the previous administrative minor modifications?
Yes.
Were you the planning director for any of those minor modifications?
No, but I was the program manager of the major development review team, which is analogous.
Okay. Did any of the AMMs require city council approval?
No. If it did, it would be a major mod and not an AMM.
Okay. Could you please turn to now this white book with the exhibits?
Yes.
Thank you, Keith. Or Mr. Niven. Thank you, Mr. Niven. Could you please turn to Exhibit A49, which is an email from Mary Lou Polly to you, dated January 17th, 2018?
Yes.
Can you please read this email?
Let me catch up. What exhibit?
Thank you. Exhibit A49.
So the email was from the mayor to myself and CC'd the city administrator. The three of us should chat. I believe this to be a major modification.
And the subject line says, tell us AMM. Does this email involve the decision that we're here today for?
Absolutely.
Okay. Could you please turn to Exhibit A50?
Yes.
Did you receive this email?
Yes.
Okay, thank you. Could you please turn to Exhibit A52?
Yes.
Were you CC'd on this message?
Yes.
And I'm going to turn your attention to Exhibit A53.
Yes.
This is an email a few days after the email from the mayor to you, dated January 23rd. Could you please read this email?
Sure. It's from the mayor to myself, and it says, can you send me a link to the development agreement and to the amendment to the development agreement? I would like to read the sections Jim is referring to before we meet. Thanks, Mary Lou.
Thank you. And is she referring to the TELUS development agreement here?
She is.
Okay, thank you. And finally, can you turn your attention to Exhibit A63?
Yes.
Did you receive this email from the mayor?
Yes.
Excuse me.
Wait, from the
did you,
city
Did you send this
administrator.
message to the mayor? Dated
I
March 3rd.
sent the one below, yes.
Okay. No further questions?
Okay.
What was that last exchange? The one below, can you help me?
The top of the email thread was from the city administrator to me. The one underneath it was from the mayor, from me to the mayor, and that was the one he was asking the question on. So it
Is
was,
that see Zach's note below?
yeah.
You want me to sign that? Okay. And I want to make sure, this this might reveal how apolitical I am, but who's administrator, who is mayor on these? The
So
names.
Emily Moon is the city administrator, and
Okay.
Mary Lou Polly is the mayor.
Okay. I think that's helpful for the record
I
as well as
agree.
for my own
In
knowledge.
fact, may I ask 3 more questions just to clarify?
Yes.
Okay.
No, you said you were done. I'm just kidding.
We're going to get you out of here well before 1 o'clock, Mr. Niven, so no worries. Did you meet with the mayor and the city attorney on this issue? So, excuse me, and the city administrator on this issue?
Did I meet with the mayor and the city administrator on this issue? I don't remember. I can't recall a meeting that we had.
Did you meet with the city administrator on this issue?
Yes. I meet with the city administrator is my direct report. I meet with her regularly on all the issues that I have dealing with, so this would have been one.
Okay, and what was
Clarify
discussed?
the question. What do you mean on this issue?
On the AMM decision.
The AMM
that you were
request.
about to issue.
Right. The
Not an
request.
issue of is it major or minor, just on
Correct.
what should I put in this
On this decision.
decision? Okay.
Whoa, I didn't say that. So we met to discuss the AMM request. The city administrator and I did not get direction from the city administrator on what decision to write.
Okay.
And that seemed like that's what that was inferring.
Did you ever meet with the mayor on the AMM decision that you were about to render?
The only meeting I can remember was with the mayor and Dan Hayes, at Mr. Hayes' request. And this topic did come up as part of that discussion.
Okay. So in Exhibit A49, when the mayor says, the three of us should chat, I believe this to be a major modification. Did the three of you have that chat as requested by the mayor?
No.
Was the mayor involved in any way in this decision?
She clearly made her position known, but no, the decision was issued by myself in consultation with the city attorney's office.
Okay. Thank you. No further questions.
Okay. Mr. Lau,
Thank you.
questions for Mr. Niven?
Thank you, Mr. Examiner. Mr. Niven, in processing this administrative minor modification request that was received by Talis Management at issue here today, did you follow the process that you had previously followed for prior AMM requests generally?
Generally, yes. This one was a little bit different in that the scope of it was, I think, less clearly defined in the development agreement than previous AMMs.
And I believe that Mr. Eckert, in his direct questioning of you, asked you a series of questions regarding whether you were aware of a provision in the development agreement that would characterize and I'm paraphrasing here, and I apologize if I'm getting this wrong, designate as a major modification the redesignation of a development parcel from utility to residential. Do you remember that
I
question?
remember those questions.
Okay. And you answered, I believe, in the negative. Is that correct?
It was not specifically identified in Appendix K.
Okay. And I believe there were a few other questions along that general line to the general effect of whether you were aware of a specific provision in the development agreement that would be characterized as a major modification of a designation of a property, redesignation of a property from office to residential, and you also answered that in the negative. Is that
Right.
correct? Okay. I'd like to call your attention to Exhibit K of the development agreement. This is in Exhibit 1, Section K, and I have it up on the board for you, specifically Section 3.0.
Okay.
This is a list of major modifications for the record. Could you please read aloud section 3.7?
3.7 is titled Other Changes, and it reads, any other designation or change that does not qualify or was denied as an administrative minor modification.
We'll get into this further when I call you as a direct witness, but is it your position, and your understanding, Mr. Niven, that the requested AMM from Thales in this case falls within the rubric or the scope of section 3.7?
Yes.
Thank you. I'd like to refer back to the questions that Mr. Eckert asked you regarding exhibits number 49, 50, 62, and 63.
Okay.
These are the emails that involved, in some degree, I believe, Mayor Pauley.
Okay.
Okay. First of all, in exhibit number 49, there is an email that was originally sent to you as a direct recipient and courtesy copied to Emily Moon from James E. Haney, dated January 16th of 2018.
Yes.
Who is James E. Haney?
He's a city attorney.
So is he also known as Jim?
He is.
Okay, and who is Emily Moon, the courtesy copy recipient of that?
She's the city administrator.
Does she work directly with and answer directly to the mayor?
She does.
Thank you. With respect to Mayor Pauley's January 17th email to you in Exhibit 49, which reads, "The three of us should chat. I believe this to be a major modification."
Yes.
Did that statement influence your ultimate determination in issuing your March 5th decision at issue in this appeal?
No.
Okay. Did you consider it?
Yes.
Okay. So is it accurate to say that you were aware of Mayor Pauley's position, but that you were not influenced in your professional judgment with respect to the ultimate decision that you reached on March 5th? Objection. Fair enough. I'll rephrase. I'll withdraw. Did Mayor Pauley's statement in Exhibit 49 or her statement to you that we should, quote, chat in Exhibit 51 influence your professional determination as expressed in the March 5th notice of decision being challenged here today?
No.
In your experience,
Just go over that once more. The question, give me your characterization of, is it influence?
and I apologize for being inarticulate on that, Mr. Examiner. My intended question was whether or not those two exhibits, and specifically the statements from the mayor in those exhibits, influenced Mr. Niven's ultimate determination as
Influence
expressed.
the ultimate determination.
Correct.
That's the key.
Correct.
Okay. Thank you.
Mr. Niven, who is the city's chief executive officer under the city's form of government?
The mayor.
Okay. And do you routinely meet with the mayor regarding matters that are within your purview as Development Services Director?
More as needed basis.
Okay. Is it unusual in your experience and observation for the mayor to provide comment or express his or her opinions regarding pending land use applications?
No.
Thank you. Mr. Examiner, my remaining questions for Mr. Niven will be posed during direct examination during the city's case in chief. I have no further questions at this time.
Thank you. Anything from you, Mr. Eckert? Thank you, Mr. Niven. I think stay right there.
I was going to say, I'm going to stay here.
And is it, now you're completed with your witness presentation?
Yes, sir.
Okay. I'll give you an opportunity for closing if you want that, following the city's presentation of witnesses, which we'll turn to now.
Mr. Examiner, should the city provide its opening statement at this
And
point?
I thank you for reminding me. If you'd like to do that now, I'm prepared to listen.
Very briefly, thank you, Mr. Examiner. As the examiner is aware from the voluminous and direct briefing in this case, as well as the motion practice, the court issues implicated by this appeal are ones of ultimately contract interpretation. And as such, those are essentially purely legal issues, and those have, I believe, been adequately and thoroughly briefed by the parties. In sum, it is the city's very strong belief in this case that the request that had been made by Talus Management Services in November and December of 2017 should be processed as a major modification. And the reason for that is that the development agreement nowhere designates or allows for an AMM to include and encompass the designation of property that is currently designated for a non-residential use to a residential use. The specific enumeration of administrative minor modifications is very clearly set forth in Appendix K, or Attachment K of the agreement, and none of those provisions, none of those criteria apply in the instant circumstance. And because of that, we are left with the catch-all provision set forth in Section 3.7 of Appendix K, which is other changes, which provides by its terms that any other designation or change that does not qualify or was denied as an administrative modification is by default a major modification. That's the default principle. That's the guiding default principle that should control the outcome of this case. Because there is nothing in the development agreement that specifically designates the type of request that has been made by Talus Management Services as an AMM, it is and must be, as a matter of law, properly characterized as a major modification. The director's March 5th, 2018 determination on appeal here accurately and correctly reached that conclusion, and I think it's borne out by the city's briefing and the rules of interpretation that the city has cited. As was reiterated by each of the witnesses who testified for the appellant today, the timing and the procedural timing of the city's processing of the AMM request was generally consistent with past practice. To the extent that there was any additional time necessary, I think Mr. Niven accurately and adequately explained why that was. Throughout the appellant's case, there is a strong undercurrent here of some type of improper tampering or meddling or interference by the city's elected officials. And the record simply does not bear that out. As Mr. Niven has just testified under oath, he was not influenced, much less improperly influenced, by the mayor's position in this matter when he was making his ultimate determination. There has been nothing in the record materials and the exhibits that have been presented here today that would discredit or otherwise refute that. And I respectfully note for the record that there's well-established case law in Washington that public officials are presumed to act correctly and in the public interest. We're happy to provide a supplemental briefing on that point, but nothing has been provided here today that would overcome that presumption. To the extent that there is any ambiguity in the development agreement itself, the director's interpretation of that document is and should be entitled to appropriate deference on appeal. So even assuming for the sake of argument that two possible and competing interpretations of the relevant development agreement provisions were possible, the director's interpretation should ultimately control as a matter of law. And then finally, I would just note before we begin our case in chief that the appellant bears the exclusive burden of proof in this case. And I think that the specific quotient of that burden is important here. The appellant must prove that the director's determination wasn't simply wrong, wasn't simply one of many possible outcomes or one of several competing possible interpretations of the development agreement, but that the director actually made a clear error, and that the examiner must be left with a definite and firm conviction that a mistake has been made in order to reverse the director's March 5th decision. And the city strongly believes that that burden has not been carried, and for that reason, the examiner is respectfully requested to uphold the March 5th decision and to dismiss the appeal.
Sounds like a closing statement to me. But
It's just to set the table.
But you set the table well, and you may have some additional evidence that you do want to submit through your witness now.
Thank you.
It's before us, and I think ready to respond to questions, and remains under oath from his earlier oath.
Thank you. Mr. Niven, you've already been sworn and introduced with respect to your professional credentials and tenure with the city. Approximately how many administrative minor modifications have you processed, or are you aware of being processed under the Talos Development Agreement?
I think the testimony of dozens earlier is probably a good summation from Mr. Fury. So there's, I don't know, I have not counted them recently, but there's probably at least 2 to 4 dozen AMMs that have been processed.
And approximately how many of those did you personally have involvement with?
At least half.
And if I understood your testimony previously, you have extreme familiarity or substantial familiarity with the development agreement itself. Is that correct?
Yeah, so I actually wrote a lot of this development agreement on behalf of the city. The original developer was Intracorp, and Richard Wilson was the attorney for them. But we basically took different leads for different appendices, and so I drafted quite a bit of the development agreement.
Were you involved in drafting Appendix K?
K?
Yes.
Not K.
Okay. Were you involved in drafting Appendix C?
I did do C.
Thank you. Have you ever approved a request for an administrative minor modification that sought the redesignation of property designated as non-residential for a residential use?
There was a lot of designations in that question. So what I would say is there has been, to my knowledge, there's been no land use redesignations in Talos.
Okay. So I think that you answered this question, but I'll rephrase it for clarity. Have you ever approved or processed as an administrative minor modification the conversion of office or utility tract designated property for a residential use?
No.
Are you aware of any of your predecessors at the city having done that, or any of your subordinates having done that?
So one of the AMM requests, and I think it's Exhibit A5 for Timber Ridge, there was a conversion of office, and that's explicitly allowed in Section 10 of the main body of the development agreement. It's called conversion of commercial to residential. So there was a very specific amount that the council approved that the master developer could convert commercial to residential, and that was used up for Talos. When we did the AMM decision for Talos, ultimately we left the land use as office because we viewed Timber Ridge as a business, and those converted residential uses were an accessory use to the commercial operation of that business. So the land use itself stayed office, commercial, which is why the map doesn't show a delineation, and Timber Ridge is residential.
So was the Timber Ridge situation that was discussed or set forth in Exhibit A5 equivalent or analogous to the Talus Management Services AMM request that is at issue in this appeal?
It's not at all.
Thank you. Putting up on the board, the excerpt from Exhibit 1, this is from the development agreement, and specifically in Appendix or Attachment K. I'd like to call your attention, if I could please, to subsection 2.1.4. This is one of the provisions of the development agreement that the appellant has relied upon here. Have you read the appellant's briefing and motion practice here?
I did.
Okay. Could you please read aloud subsection 2.1.4?
Sure. 2.1.4 of Appendix K states addition of consistent uses, and it says addition of uses consistent with the permitted uses set forth in Appendix C, paren land use, unparen, unless the additional use or uses represents a major change in the Talus project concept as described in Appendix A, paren, planning goals, unparen, or Appendix B, urban village design guidelines, that's in parens, in which event the proposed addition shall be deemed a major modification.
Mr. Niven, do you believe that the Talus Management Services AMM request falls within the scope of this authority in section 2.1.4?
I don't believe that this particular section, 2.1.4, deals with the request. I think this particular section deals with the addition of land uses that would be deemed consistent with those land uses that are allowed in Appendix C land use chart.
So just to clarify that, Mr. Niven, is it your interpretation or statement that the addition of land uses, as referenced in section 2.1.4, means new land uses that were not within the original designation of the permitted land uses under the agreement?
That's exactly what it means.
Okay. And could I call your attention to Appendix or Attachment C of the development agreement, and specifically 4.0 of Attachment C?
Yes, 4.0.
Okay. Okay. Could you please read for me the enumerated permitted land use categories in section 4.0?
Sure. It says 7 main land use, it's called land use established. 7 main land use categories have been established for Talus that will dictate development type and characteristics. The 7 categories are A, low-density residential, B, medium-density residential, C, high-density residential, D, village center, E, office campus, F, open space, and G's utility tracts.
What is the current designated land use of the Talus parcel 17?
17 is E, office campus.
And what is the current designation of Tract C?
Tract C is G, utility tract.
Okay. As you understand it, is the requested modification by Talus that is at issue here today, does it involve the redesignation of those areas with a use that is already listed in section 4.0?
Yes,
Which use is that?
residential.
Thank you. And Mr. Niven, I'd like to turn your attention, please, to section 2.1.3 of attachment or appendix K.
Okay.
Could you please read that aloud? This is also another provision that Talus is relying on in this appeal.
Sure. Appendix K, Section 2.1.3 is titled Changes to Development Parcels. And it reads, changes to the size or shape of the development parcels from the size and shape set forth on the map that is Exhibit 3 to the agreement. And this is under the section that's 2.0, which is administrative minor modifications.
Okay. To your understanding and your belief, does the Talos Management Services request for an administrative minor modification at issue here fall within the scope of 2.1.3?
It does not.
Why is that?
So this was envisioned, this recognized that the development parcels that's shown on the map, that's C1, that we looked at earlier, that those boundaries could be changed based on the assessment of the surrounding open space being not critical. They could grow in size based on that, and that was envisioned to be an administrative modification.
Thank you. I'd like to turn your attention back to Section 3.0 of the attachment or Appendix K,
Okay?
and specifically section or subsection 3.1.
Okay.
Would you please read that aloud?
Sure. This is under major modifications. 3.1 reads changes in maximum number of residential units. And it states changes in the maximum number of residential units authorized for the Talos project would constitute a major modification.
Could you please read section 3.6?
3.6, again, under major modification, land use and building heights, changes from low to high-density residential, semicolon, or increasing the allowable building heights in any of the parcels 3, 4, 5, or 7, as depicted in Exhibit C1 of this agreement, would constitute a major mod.
Great. So do you construe those provisions as indicating a particular sensitivity to residential use intensification under the development agreement?
So 3.6, what 3.6 says to me, there's actually two very distinct pieces that are combined with a semicolon. So the first part of that sentence, which is change from low to high, so that's two density categories. And what the development agreement says is if you want to go 2 categories, it now becomes a major modification. The second part of that sentence is really dealing with view impacts that came out of the EIS. And if there were any building height addition requests to those specific parcels that were listed, those would have to be a major modification because of the concern for community view impacts.
Thank you. I'd like to draw your attention now to section 2.1.9. This is back in a list of enumerated changes that can be processed as an administrative minor modification. Could you please read aloud that subsection?
2.19?
Yes.
It's titled Changes in Residential Density, and it states residential parcels may shift one category upward in parens more density, or 2 categories downward in parens less density.
So do you construe that provision as allowing a modification to be processed as an AMM where the proposed change is?
Objection.
Do you construe the Talos Management Services modification request at issue here today to fall within the scope of that exemption?
No.
I need to better understand that. I don't know what a category shift is. Is that addressed in the Talos agreement, Mr. Niven?
Yes, sir. Excuse me, going back to Appendix C, So if you go back to 4.0, Mr. Examiner, you see the A, B, and C of 4.0 is low-density residential, medium-density residential, and high-density residential. A, B, and C under 4.0.
I see that.
So those are the three categories of residential. So what this particular section 2.1.9 says is if you go upward one category, like from low to medium or medium to high, that's allowed. But if you were to go two, that's not allowed.
Thank you.
Mr. Niven, do you construe section 2.19 as applicable where a property, the underlying property at issue is not already designated as residential under the development agreement?
No.
Thank you. Mr. Niven, I'm putting up on the display board an excerpt from Exhibit C, specifically sections 9.0 and 9.1. As you indicated, you were aware and familiar with the appellant's briefing and arguments in this case?
Yes.
Okay. As you are aware, the appellant has contended that these two sections or subsections of the agreement should authorize the Talos Management Services AMM request to be processed as an AMM. Do you agree with that?
No, I do not. I mean, so I'm going to take a few minutes to just narrate. So, 18 years, you write these agreements, you try and write them clear. I think, candidly, there's some ambiguity here. I think if you look at specifically K 2.1.2.3, this is where it starts to have a conflict between that section of Appendix C. So I'm not sure if you were ready to go there or not, but it seemed like I needed to thread those two pieces together because I think they show a conflict. And so when we wrote C, and there was, I think, some concern by then City Attorney Wayne Tanaka that we had this section in C when it should really be in K. The way we tried to not have a conflict was we had this section refer to Appendix K.
So if I understood you correctly, Mr. Niven, the attempt to reconcile what you, I believe, characterized as some potential ambiguity or conflict involved the cross-reference in Section 9.0 and 9.1 to Appendix K?
That is my recollection of the conversation we had a long time ago.
Do you construe Section 9.0 and 9.1 as excusing an applicant's compliance?
Objection, this is leading that.
I would,
Construe it to be, he's testifying
I
here.
was going to culminate that in a yes or no answer.
Why don't you complete your question?
Thank you.
You construe it as,
Do you construe Sections 9.0 and 9.1 as obviating or otherwise excusing an applicant's compliance with the standards set forth at Appendix K?
No, no. To the contrary, I think what we were trying to do was tie these two in C to K.
Thank you. Mr. Niven, were you in the hearing chamber today for the testimony of Mr. Fury, Mr. Pugh, Mr. Bellamy, and Mr. Mullaney?
Yes, I was.
Okay. Did you ever, in your communications with any of these individuals, promise or assure them that you would process and/or approve the Taos Management Service AMM request as an administrative minor modification?
No.
I'd like to turn your attention to a few of the previously issued AMM decisions that were cited by the appellant, both in the briefing and in testimony today. First, I'd like to return to I believe it's the Timber Ridge matter. This is AMM or AM 04-001 EV, and that is
Exhibit 5.
Exhibit 5. Are you familiar with that document?
I am familiar with this document.
Okay. Could you briefly describe the request and decision at issue in that matter?
I'll do my best. This was actually penned by one of my staff members, even though I signed it. So Timber Ridge is a complicated land use. It is independent living, nursing care, assisted living, all kind of rolled into one project. And so what this decision tried to do was to reconcile how the city was going to account for the amount of square footage and the residential units that were going to be part of Timber Ridge. And so, a lot of it had to deal with allocating units based on size and purpose.
Mr. Zell, can you share with me why I need this level of detail? The question was just, what's the request? It's very clear. There's a sentence
Yes,
right on the
Mr. Examiner.
document.
I believe that the appellant has introduced these prior decisions into the record for the purpose of, I believe, attempting to demonstrate some type of inconsistency
Yes.
with respect to the city's at-issue decision in relation to the previous decisions. And I'm
Or
asking
as precedent that shows an
Correct.
established pattern, which goes to
Correct.
difference. But you also cross-examination of those witnesses. And wasn't that the opportunity to go through that?
This is the city's case in chief. My intent through this line of questioning is to provide a further level of detail regarding the underlying request and specifically the designation or lack of redesignation of the property.
Okay, I
If
think
the-
you established that. It's clear on its face. Isn't it the last sentence on page 1?
Fair
Is that
enough.
where you're going next?
That was,
Okay. I just would ask just quicker
certainly.
answers because I'm concerned about running out of time. I want to allow for cross-examination.
I understand, and I will take that to,
Okay.
thank you. Mr. Niven, you are familiar with all of the previous AMM decisions that were listed as exhibits in today's proceeding, on at least a general level, is that correct?
Yes.
Okay. Do you believe, or is it your opinion that any of those decisions are analogous to today's proceeding or today's AMM request?
No.
Are they all distinguishable on their facts or based on the regulatory standards implicated?
Yes.
Thank you. Okay. I'd like to shift now to your communications with the mayor
Sure.
and her office, and I won't rehash old territory, but I just want to emphasize for the record, when you drafted or processed and issued the administrative minor modification decision challenged here, did you have any communications with the mayor's office that were not reflected in the exhibit list today, to your recollection?
None to my recollection.
Did you deliberately discriminate against Taos Management Services in processing and making your decision in this matter?
I don't believe so. I think that the way this kind of came about was they came to us and asked for help to try and figure out how to do something before the development agreement ended. So we suggested applying for the AMM as their only mechanism to do that without a council action, and really spent the time both procedurally and substantively working through that request, which is why there was requests for additional information on the substance. But we came to the conclusion that procedurally, it was not an AMM.
Did you reach that conclusion after consultation with the city attorney's office?
Absolutely.
Did you reach that conclusion after your own personal review of the development agreement?
Yes.
At the time that you had suggested to the applicant's representatives that they might submit an AMM request, had you performed that in-depth review of the development agreement?
No.
Had you consulted in depth with the city attorney at that time?
No.
I have no further questions.
Any cross-examination of this witness?
A few questions. Mr. Niven, you mentioned there was a conflict of ambiguity between section 9.0 and 9.1. And then you cited a section.
You're not on, Jeremy.
Mr. Niven, thank you for telling me to turn on my microphone for the record. Appreciate it. You mentioned a conflict or ambiguity between section 9.0 and 9.1 and some provision in section K. What provision in section K did you cite?
So the provision in section K, I think, is, let me get back to K. So when you look at 2.1.2.3 under administrative modifications, 2.1.2.3, and I can read the whole thing if I need to. I'd rather not. Oh, it's up on the top of the board. So it sets some boundaries in terms of land use changes that would be allowed as an admin decision. And I think what's been asked for is beyond that. So I think that's where, you know, if it doesn't fall within the admin decisions as 3.7 says, then it's a major mod.
But isn't it true that that provision that you just cited is nested under section 2.1?
I'm sorry?
Isn't it true that the section that you just cited, which is
Yes.
2.1.2.3, is nested under 2.1?
Nested, yes.
Nested.
Sorry,
thank
I
you.
missed that nest.
No problem, it's nested, yeah. And here it says 2.1, I'll just read aloud, that says, administrative modifications are included, but not limited to the following changes. So isn't it true that this
Mr.
is just,
Examiner, I'm going to respectfully object to an isn't it true line of questioning. If the form of the city's questions were inappropriate, I would suggest that that's inherently leading.
this is cross-examination.
There is more flexibility in cross-examination. I suppose, is it true or not true? What would be the specific objection to that you made was to the form of the question, isn't it true?
Yes.
And I don't see a problem with that.
Fair enough. Object for the record, but thank you.
Okay.
Thank you. So Keith, Mr. Niven, apologize. Would you agree with me that the bottom of section 2.1 says that the AMMs are included but not limited to?
Yes.
Okay. When did you become aware of this purported conflict between section 9 and section 2.1.2.3?
In terms of specific days or when in the,
When in the process?
when the process. So as I mentioned earlier, I was trying to work through both the substantive criteria of the AMM and the procedural piece, whether it was an AMM or a major mod. As we, started to unpack different sections of the development agreement, and we would be myself and the city attorney. We got to that point, so it would probably be somewhere around the date of the emails that we've looked at earlier. The one with the big redacted one, that's about the date, would be my guess. That would be
Mr.
Exhibit
Eckert,
49.
remind me, and I know he's in the middle of your response, so hold that in case you do respond. I got a lot of pre-hearing material to go through, and I went through it, but I don't have a recollection of every argument that you made. Remind me why this is an important part of your case. What point are you making when I look at the section 9 of Exhibit C? There is the last sentence does refer to K, and in direct exam, we heard him refer to that. But tell me, where do you go with that? What is your argument?
The issue is, why would he direct the applicant to file the administrative minor modification if he was aware of this at the outset? And I'm just trying to figure out at what point.
Okay, no, that's helpful to me. So your position is, gee, he should have done something different? He should have helped your client know about this provision and then direct a major modification? How do you follow that?
Following what we,
Was the failure of the administrator to not provide more specific direction? 'Cause I'm not sure I'm on track with you on that. That's why I'm asking this question. And in preparing for a hearing, I'm not always aware of what issues are going to go forward. But now that you're focused on this, I need a little bit more from you about why it wouldn't be important and what would you expect me to rule on with this conflict or not conflict between Appendix C and Appendix K.
Thank you. There are a handful of items here. One is, our position is that Appendix C speaks for itself. That's what we're saying to you. And it does cite Appendix K. But Appendix K with these minor modifications are all permissive. These are included but not limited to the following minor modifications. And the top of the section 9 says, unless otherwise specified, which means with specificity.
Okay, and that's really been helpful, and you've helped
Yeah.
me understand that. My question again is, what ruling would you expect me or ask me to make based on these two appendices?
Yes. I would ask you to argue that there is no conflict between these two. And therefore, there is no reason for the director to interpret the development agreement.
Okay, thank you. And you want some additional questions about that to have Mr.
I just have,
Niven-
I'm going to move on from that, and I have one quick question about Exhibit C.
Okay.
Thank you. So, Mr. Niven, you previously testified that you were not aware of a change of a land use designation from anything to residential. Is that a fair statement? From office to residential?
Any land use
Any land use
designation
to
change.
residential?
Right.
Okay. And then could I direct your attention to Exhibit C, please? Exhibit 6.
Thank you.
The
My
lady
did have
behind me.
letters.
Yeah. And I believe you testified that you were familiar with this AMM?
Yes, sir.
Okay. Well, so isn't it true here that in this AMM, parcel 16 was pushed into parcel 17 so that real property that was previously in office use was allowed to be turned into townhouses?
So I'm gonna answer it my way, and then you can redirect me. So changes in the development parcels is allowed as an AMM under 2.1.3. And I see this as a change in the boundaries of a development parcel and not a change of land use.
Okay, let me rephrase my question then. Isn't it true through this AMM that there was a real property, dirt, in Tallis that had an office use, but then this AMM changed the line so that real property, which previously had an office use, could then be used as residential?
So, sure, yes.
No further questions.
You want redirect?
Very briefly. Mr. Niven, going back to Exhibit 6 and the notice of decision for AM 03-006 EV, the decision that you were just discussing with Mr. Eckert,
Yes.
okay? Could you please read the request statement of that document on page 1?
Sure. Application for an administrative minor modification to redesignate a non-critical area open space south of Talus Parcel 16 to be included in Talus Parcel 16.
Does the Talus Management Services AMM request at issue in this proceeding involve a request to redesignate non-critical open space?
Sorry, I was reading. Can you say that again?
Does the Talus Management Services administrative minor modification request at issue in this proceeding involve a proposal to redesignate non-critical area open space?
No.
Thank you. Mr. Niven, you were asked about potential or possible conflict between Section 9.0 and 9.1 and other provisions of Appendix K.
Yes.
When you read the development agreement and when you read the development agreement for purposes of issuing your March 5th decision, do you limit your analysis to a particular section in isolation, or do you consider all relevant provisions of the agreement?
So my understanding is this entire document's a contract, and so we look at the entire document.
Did you do that for purposes of rendering your March 5th decision?
I did.
Thank you. No further questions.
Okay, thank you. I'm curious, Mr. Niven, your testimony, there's between 2 and 4 dozen administrative modifications under the Talus agreement. And I'm just wondering, with all the record keeping, is there actually a file of these are the administrative modifications? Because we don't have a specific account. It's somewhere between 2 and 4 dozen. But could you determine exactly how many were made?
Absolutely. We actually have them in a 3-ring binder.
Okay.
Would you like that number?
Well, no, I just, though it seemed curious to me that we didn't have an exact number, 2 to 4 dozen. I mean, I'm left, and then you said, well, I was involved in at least half of those. So that may be as few as 12 out of as many as 48. Then you take 2 to 4
Sure.
dozen were made,
Sure.
but you were involved in maybe half. And why wasn't there more precision? And this is where I'm going. Did you actually look at each one of those 2 to 4 dozen administrative modifications to prepare for this hearing today?
Oh, no. I don't know why I would. So most of those administrative modifications were parcel-specific decisions. As we looked at a specific request for building height extension on the
Okay.
office space, right?
And that's helpful, but because the testimony is that there's been no other request for a redesignation of land from, for example, office to residential. Without looking at each one of those.
Oh, no. That's not even a choice. So I hear what you're saying, and what I would say is I'm pointing down to that map
Well,
that's...
just to clarify, I'm not saying anything, I'm asking a question.
So and what I'm saying is that map down there, there's very specific development parcels. There's not a lot of them. There's very finite number of development parcels. I've been involved in every land use decision in Talus. And what I would tell you is there has been no request for a change of land use in Talus other than this one that led to the denial. I'm conclusive on that point.
Well, and I guess now the terms that you're using, because we just looked at the Exhibit 6, which was a request for redesignation from non-critical open space.
But that's not the same as changing land use, and it's allowed specifically under the AMMs in Exhibit K.
Okay. All right. Now, was your witness, if I opened up something, please, you can ask questions. If there was anything there that...
Just
like
to
to
follow up, thank you, Mr. Examiner. I know that, Mr. Niven, you did not personally review every single one of these potentially 4 dozen prior AMMs under the Talus agreement that have apparently accrued during the last 2 decades in preparation for today's proceeding. But the examiner asked you a question about the specific number and about the content of those prior decisions. I just want to reiterate a point, or have you reiterate a point. Are you aware of any prior decision processed as an AMM for the Taos Development Agreement that involved the type of redesignation to a residential land use at issue here today?
No.
Thank you. No further questions.
Any
No,
question from you?
examiner, but we would like to call one rebuttal witness. I promise it'll be brief.
That's fine. Please do so.
Okay.
Thank you, Mr. Niven, for being here today and for your testimony.
I'd like to
Now,
call-
rebuttal witness from the appellant.
I'd like to call Al Fury. Mr. Fury, could you please turn your attention to Exhibit A6?
Yeah, I have it here.
Okay. And you testified earlier that you were involved in preparing this AMM request, is that correct?
Yes.
Okay. And we just heard Mr. Nevin state that this did not change a land use designation.
Yes, I heard that.
What is your response?
Well, and I don't know if it's semantics, but a portion of 17 that was mapped in the original land use exhibit in the development agreement became residential.
Okay. Could you turn to Exhibit A3?
A3?
Yes. And I am 1, 2, 3, 4, 5, 6, 7, 8. And if you could turn 9 pages back to the survey, this says Triad Associates on it.
Which exhibit?
Exhibit A3?
Is it one of the attached exhibits?
Correct. So,
Oh, you mean in this, in
Yes,
in Exhibit 6?
no, Exhibit A3.
Is it an attached exhibit?
Yes, is an attached exhibit to A3.
And that exhibit attachment is numbered 3, is it?
And it's, I'll just show it to people if it's here. It's this exhibit.
Okay, yeah, that looks like it's exhibit 3 to A3.
You're correct, of course. Thank you.
Boundary line
In,
adjustment survey.
Right, yeah, exhibits, the attachment in Exhibit 3, yeah, 3, okay, that's, okay. 3.
Okay. Can you use this exhibit to describe what happened in the AMM identified in Exhibit 6?
Sure. So the crosshatched area that you see was formerly Office 17O, and it became residential 16-3 and a portion of 16-2.
Okay. And this was approved through the AMM process?
Yes.
Okay. Just 1 second, examiner. So did the city designate open space to residential development through an AMM?
Repeat that?
Did the city designate open space to residential development through an AMM?
Yes.
Okay. No further questions.
Okay, thank you. You want to ask a
Yes.
question?
Yes, please, Mr.
Oh, okay,
Examiner.
I'm sorry. We have a city attorney would
Yeah.
like to ask a question on the cross-examination of this rebuttal witness.
Thank you.
Please proceed.
Mr. Fury, in Exhibit 6, the notice of decision that you were just referencing for AM03-006EV, what parcel did that involve?
It involved parcels 16 and 17.
Okay, so with respect to parcel 16, the parcel that was truly at issue there, could you please go to Exhibit 1? And attachment C?
I don't have an Exhibit 1.
Oh,
Well, that's the
development
development agreement.
Oh,
That's the black binder.
all right. Where here?
I'm sorry, Exhibit 1, attachment C, or Appendix C, excuse me. And Section 4.1.
Yes.
Okay. In that table, could you please scroll down to development parcel number 16
Yes.
and read for me the proposed land use that correlates to that parcel?
Yes, it says Village Center.
And with respect to the far right column under the heading projected density range, could you please read me the corollary reference for that parcel?
Sure, 30 to 60.
Thank you. No further questions.
Thank you, Mr. Fury. Well, I think all witnesses have been presented, and there's been an opportunity for direct and cross-examination and redirect, also for presentation of rebuttal witnesses. So I believe we've completed the process of hearing today. If each attorney would like to make a closing statement, I indicated maybe I heard one from Mr. Zell, but we'll give you another opportunity to do that. And if you'd like to also, Mr. Eckert, I'm prepared to listen to that.
Good. I would defer. I would like to have a closing statement, but I, of course, defer to Mr. Lell if you'd like to make any comments.
No objection, and the appellant should go first, obviously.
Okay.
If I'm not mistaken, doesn't the appellant go last for closing statements?
I'm
It's whatever I decide.
I would defer to the examiner.
Defer to the examiner.
Well, are you prepared to go forward? And the reason I would is because I think we heard from Mr. Zell with a summation of what he believed he heard from the witnesses today, other than his own witness on direct.
Very good.
So I think his will be a brief closing.
Very much.
And I wanted to give you a chance. And if you need, do you need a couple of minutes to pull things together?
Yes, that'd be helpful if I could have 3 minutes. That would be
Yeah, I
most
think
appreciated.
that's fair. We can just kind of, we can stay on the record because it takes so long to get started and stop, and just kind of cool our heels and let you prepare and consult with whomever you'd like, and then come back when you're ready.
Thank you.
Are you ready?
Yes, I am, Examiner.
Okay, please proceed with your closing argument.
Thank you very much, Examiner, and I appreciate your time today, and I appreciate Council's time putting into this. As you heard today, the Talos Development Agreement authorizes an approved bucket of allowed commercial development, and this development's all pre-mitigated and pre-approved. the development agreement authorizes an administrative minor modification provision to move around this bucket of allowed pre-mitigated development. And the development agreement also includes a provision entitled flexibility objectives, which allow the master developer to respond to market conditions. Here, as you heard, the master developer requested a minor modification to change the land use designation and from 17B to go from office to medium density residential, and for utility tract C to go to medium or high density residential as chosen by the director. And the process provision of this appeal boils down to Section 9, which I have here next to me. And what Section 9 and 9.1 state is that changes in land use designation, which is identified right here, should be processed as a minor modification unless otherwise specified, which is the beginning to the Section 9.0. And specified means to name or state explicitly and in detail. The decision denying the AMM does not cite to any specific provision. Instead, it admittedly relies upon this broad catch-all provision, which Director Niven testified to. And the director talks about some potential conflict between Section C and Section K. But as we heard earlier, Section K, the list of minor modification provisions, does not say this is an exclusive list of minor modifications and everything else isn't. It's a broad list that includes but is not limited to. The city attorneys repeatedly turned to the use table in Appendix C 4.1, but that use table is also preceded by broad language saying that this is what we think this might be, but we can move it around. And you heard that testimony earlier today. So there's a hierarchy in this contract interpretation, and it starts with the plain language, which we argue is 9.0 and 9.1. There's nothing that contravenes this plain language, and the director cannot interpret the development agreement to contravene the plain language of the development agreement. And you also heard Director Niven today state that he could not point to a specific provision of the development agreement that would lead him to conclude that it was a major modification. Admittedly, there is one change in land use designation that would trigger a major modification, and that's specifically enumerated in Appendix K, and that's going from low to high residential density. That is the one that's identified as a major modification. That's the one that's otherwise specified. We also saw today that the city has approved at least 5 administrative minor modifications that are contrary to the city's new position. The biggest one that we just hit was Exhibit A6, which is the AMM authorizing a change in land use designation from non-critical open space to village center. And we also saw that it allowed a shift from office designation to residential. Now, the real property was allowed to have an office use, and after the AMN was complete, it allowed for residential use. We also see Exhibit A7, which authorized a change in land use designation from utility tract to office campus, and A5 and A10, which we talked about before.
Let me ask you about those.
Yeah.
Do you offer those as precedent that must be followed, or is it for the purpose of exhibiting a pattern that goes to the deference that needs to be granted?
I'm happy you asked that. There's 2 reasons why. First, under Sleesman v. Lacey, the question is the director entitled to deference? Because the director is the one who is managing this development agreement. And in Sleesman v. Lacey, the court said, the director is only entitled to deference if it can be shown that it's based upon a pre-existing policy. And what these AMMs show is that no deference should be given to the director because not only is it not based upon a pre-existing policy, but it's strictly contrary to previous decisions. The second one is more of a contract argument, which goes to course of dealing. And that goes to, and I want to point out Exhibit A9. And this is an AMM that did not deal with changes in land use designation, but it's perhaps the most telling because in A9 and Rationale 4, this is where the director said, unless the development agreement explicitly identifies the request as a major modification, we will process it as a minor modification. Again, that's the opposite of what's happening in this decision. So we just discussed, the city's briefing says the AMMs are irrelevant. But we strongly disagree for the two reasons we just discussed. And as we talked about before, and perhaps the most contested argument isn't the process, because I think it's clear that it needs to be a minor modification. But I think the issue now is, what direction should the examiner give to the city? And we are requesting that that the hearing examiner remand back to the director to process as a minor modification with directive to approve the AMM request. The reason why we say that, and I don't say this lightly, is that the record shows that this issue was prejudged and that it was based upon political opposition. And I respect Keith and Mr. Nevin with what he's saying, that this was his decision, but when you have the mayor in an email at 8:51 stating that she believes that the request to be a major modification, that's a lot of pressure. And the record also shows in Exhibit A51 that Mr. Nevin was telling members of the Taos community that he was poised to approve the request for 17B, and that changed after the mayor made her position known.
How does the mayor position prejudice your client? And couldn't it be that the mayor wants to see this come through a council process to express her support for the request?
My client is entitled to the terms of the development agreement. And what my client signed up for was to allocate the ERUs, the bucket of development, go through an administrative minor modification process, which is non-political process pursuant to the terms of the contract and processed within a matter of months, not to go through a political process where the city's own files, which are now admitted, I'm looking at C3, I'm looking at C4, C5, where we have Taos members, go ahead, I'm sorry.
You have protections, though. I mean, you can't, all land use is partly political, partly legal. But it's not supposed to be, right? It's all supposed to be legal. If you're mayor, and I catch your drift, you think there's a decision already made, but you can ask for recusal. You can show prejudice at that level. Why is that major modification process of such concern?
I'm happy you asked that. The master developer signed up, as Mr. Pugh testified today. The master developer bought into the Taos development agreement specifically because of the rights afforded to the master developer under the development agreement, which included allocating these ERUs through an administrative process. I think we can all agree that the administrative process is likely cleaner than the public hearing city council public process. So my response is that the master developer is entitled to have his rights honored as under the contract. And this is a contract proceeding as much as a land use proceeding.
So by cleaner process, do you mean less political?
Correct. Faster, less political. It goes before a trained staff as opposed to a city council, which may or may not understand the nuances of land use. This is what the development agreement authorizes. This is what 9.0 and 9.1 is all about.
Okay. You really don't know the outcome
We
of
couldn't.
the process.
But what we do know is that underneath the development agreement, there's clear criteria surrounding land uses, adequacy of roadways, location impact to critical areas. There are 3 issues to address. And like you just said, we don't know what to expect in the political process. It could be anything.
But you have protections.
Nothing under the development agreement would force the city council to approve the major modification. It's a discretionary decision. So I suppose I disagree with the statement that we have protections. We would be
Well,
before.
one of the, and you didn't really pursue it with presentation of evidence, but the statement made was this was based in part on community opposition. And if you have an opportunity to show that as part of a major modification process, which you are articulating probably would be more political, including statements of opposition, you do have a protection under a lot of case law dealing with that.
I do agree with that statement, yes.
So maybe I need to give you that opportunity. I don't want to signal where I'm going. I really don't know how I'm going to decide this, and I'm sorry to interrupt your closing. You're doing very well. You've made some very good statements. I promise I won't interrupt again.
We would ask that you do not give us that opportunity. We respectfully request that because of the terms of the development agreement.
Yep.
And it's not the same to say to go before the city council to request a discretionary decision versus processing an administrative minor modification that has 3 defined approval criteria.
Okay,
And so with that, I thank you very much for your time today.
thank you. Mr. Lell, do you have any closing remarks you wanted to make?
Very briefly, thank you, Mr. Examiner. First is that sections 9.0 and 9.1, which the appellant has relied upon, I think, very heavily throughout this proceeding, are very telling in the language that they use. The first point that I would make is that Appendix K is referenced in those 2 sections 4 times. And from the city's view, and this is reflected in the Development Services Director's March 5th decision, that indicates a contractual intent that sections 9.0 and 9.1 are not intended to supersede or obviate compliance with Appendix K. They specifically refer to Appendix K. And for that reason, Appendix K has to be construed in tandem with and in harmony with 9.0 and 9.1. Nothing in 9.0 and 9.1 gives the Development Services the director to override Appendix K. And Appendix K is where the substantive criteria are for determining whether a particular modification request should be processed as an AMM or a major modification. And that's the thrust of the director's decision. And with respect to the appellant's position, I don't believe that their interpretation of the contract gives proper credence to that harmonization, which as a matter of law must occur. With respect to the prior AMMs that have been submitted into the record, 2 points. First of all, as a matter of law, previous land use decisions are not binding on the city. I think there's a significant body of case law that underscores that. Many of those cases are cited in the city's briefing. That's a body of law that goes back several decades. Each land use decision must be processed, construed, and made on its own merits. And in the event that the city at some previous point may have made a mistake, the city is not legally required to keep making that mistake in the context of future decisions. Second, and more fundamentally here, as you heard from the testimony, none of those previous A&Ms are analogous to the situation at issue in today's proceeding. None of them involved a fundamental redesignation of a development parcel under the Taos Development Agreement from a use that did not involve residential uses in any respect to a use that is residential. And the agreement itself differentiates between various uses. It assigns density ranges to particular uses, and it is very telling that under that document in Appendix C, neither Tract C nor Parcel 17 even list the possibility of residential uses. It doesn't even provide a range of potential densities. And that really underscores that residential reclassification in toto is something that the City Council wanted to reserve for itself through the major modification process. That's really the core of the director's interpretation. Finally, I would circle back to the burden of proof, which we feel is very important here. Even if there were competing interpretations of this document, this development agreement, possible, the appellant has not carried its burden of demonstrating that the director's interpretation is clearly erroneous. At most, the appellant has demonstrated that differing interpretations are possible, but not that the director's interpretation is clear error. With that, the city rests. Thank you.
Thank you. Okay, I guess it's up to me now. I'm clearly not going to rule today, but I do want to express appreciation for City Attorney Zach Lell. I've seen you in other proceedings. Always a pleasure to be with you.
Thank you.
As an attorney representing the city's interests. Mr. Ackerman, the first time I met you, you clearly did a lot of preparation for this. I respect you for that, and did a very good job in presenting your case.
Thank you.
So you're welcome in the hearing room anytime. As those of us that are aging move on, we welcome younger members into the land use bar. I'm glad to have you as part of that bar. So Thank you
Thank
for
you.
your presentation.
Thank you.
Now, for me, I have a lot of stuff thrown at me, a lot of pre-hearing material, a lot of witness presentation today, and I appreciate you both really moved forward quickly. And I scrambled to take notes, but I did take a lot of notes, and there's a lot of different sections now for me to interpret and apply, and a lot of exhibits to refer to. I may not refer to every exhibit in my decision, just as you did not in your presentation of case. And that doesn't mean I'm ignoring them. It means I didn't find them sufficiently relevant to indicate in my findings. But I do have all the material I need. I know the direction I'm going. I'm hoping to have this issued within the next 10 days. So we will make every effort to do that, and I'll notify you if it's going to take longer, but I think it will be within the 10 days. Okay,
Thank you.
and thank you too. We made it just before 2 o'clock. So we'll now adjourn.